Yes, please hand over all the slips.
No, Lordship, one thing.
Upgradation only, right? That it will be upgradation.
Lordship,
Revision also, please hand over all the slips in upgradation, right? Upgradation.
Electricity matter,
Saturday,
your
Lordship,
Lordship,
very urgent
grant
matter,
leave.
your Lordship.
Grant leave to move them one matter, Lordship, today itself. On Saturday also grant leave, Lordship. It is item number 51. I am not traveling, Lordship. Kindly fix it Wednesday at the top, Lordship. It's a
My lord, it's very
urgent matter, Lordship. Wednesday at the top.
51.
51.
51 to Wednesday stop করে দাও।
Much available.
my lord, please take this matter today, my lord.
হুজুর নমস্কার, আমার কিছু বলার আছে।
আপনি লাস্টে বলবেন, আপনি ইন পার্সন অ্যাপিয়ার করছেন, আগে লয়াররা বলে নিন। ইয়েস
My lord,
It's a very urgent matter. My technical beat has been cancelled, my lord, on the ground of a
Leave to do, leave forward.
day after tomorrow at the top.
Yes, leave is granted, দিয়ে দাও।
my
Wait, some, give me some. Top matter se দিয়ে দিও, Wednesday ওটা, leave দিয়ে দাও। Yes.
Lordship, may I be permitted to move a matter where the sale has been fixed on 24th? I have filed a section 17 application, but the office of the learned presiding officer is vacant, DRT2, Lordship. I've also filed a stay application and put up, but I'm not getting a chance of hearing. I'm neither the
22nd upgraded.
I'm deeply
Leave is granted, yes.
lordship, under compelling circumstances, I'm mentioning one matter, lordship, item number 50 of today's list. Lordship, this matter has been mentioned on Friday, and the lordship was pleased to fix the matter, and today on top fixed. And
Fixed, I don't remember.
lordship,
Top
today
I
is
think
the
fixed.
date of
No.
lordship, it is written over the, it is written in the back portion, lordship, also top fixed. And lordship, today is the date for auction, lordship.
Nothing
Today
doing.
itself is a lordship,
At least it can appear as upgraded matter on Wednesday.
lordship, My it lord, is on the- fixed on
Yes, next. 50 টা upgraded দিয়ে দিও।
lordship, 2 days fixed for
Nothing doing.
auction, lordship.
You are asking for upgradation?
Yes.
I thought I was very clear. I told you if you are mentioning for upgradation, give a slip. Why are you mentioning again, wasting court's time? Unnecessary.
My lord, item
Yes, hand over your slips, please. Why are you mentioning again?
yes, ma'am, my lord, but it's not on list, my lord. It's very urgent, my lord.
Mention every matter, hand over the slips.
My lord,
Don't you understand? You hand over the slip. Yes.
my lord, under compelling circumstances, I am mentioned this matter, though it's my fault, my lord. This matter was, my lord, taken up
Yes,
on,
hand over a slip.
my lord,
There is a grave urgency, Millard.
No grave
my lord,
urgency.
this matter was,
Seconds, Millard. Thereafter,
this matter, my lord, was taken up on Friday as item number 34. My lord, it's my fault that I couldn't appear, as because at that time another matter is fixed before courtroom number 14. And my lord, this matter dated fixed is in monthly list of January. My lord,
Yes,
kindly,
your fault, then you have to suffer for
my
that.
lord, kindly,
Sorry.
Lordship, mentioning, lordship,
I am a Millard railway contractor. Millard, my business has been suspended by the railways. Millard, the 2 tenderers are going to open, Millard, in this week. Now, Millard, I have been also blacklisted. from those
Yes,
who-
hand over for upgrade matters list.
my
That
lord,
is what I told you. Why are you mentioning again?
Millard, I have not.
Upgradation matters you have to mention.
No, this is not Millard. I filed Millard last Saturday.
আচ্ছা এটা আপগ্রেডে দিয়ে দিও।
my lord, kindly.
Yes,
Millard, on 22nd, Millard.
22nd, yes, upgrade.
রাতের অর্ডারটা দিছিলেন সেটা মানছে না স্যার। আবার রেজিস্ট্রির মাধ্যমে
দাঁড়ান, বলছি।
Special fraud investigation team. The entire investigation.
What are you asking for? What are you wanting?
For listing of
Hand over the slip. Listing,
My
please
lord.
hand over all the slips.
lordship, mentioning for withdrawal, lordship.
Yes. বলুন আপনি কি
My
বলবেন?
lord, kindly,
বলছি যে আমার 15992 অ্যাপ্লিকেশন নাম্বার
আপনি নিজে অ্যাপিয়ার করছেন, কোনো লয়ার নেই?
নিজে অ্যাপ্লাই করিনি আমি, লয়ার করে, কিন্তু আমার যা পরিস্থিতি 5 বছর যাবত রাজনীতি
লয়ার যদি অ্যাপিয়ার করে আপনি নিজে ডাইরেক্ট মেনশন করতে পারেন না, লয়ারকে দিয়ে মেনশন
আমার
করাবেন।
আটকে গেছে সব, একদম মানে বন্ধ হয়ে গেছে। আমরা
লয়ার দিয়ে অ্যাপিয়ার করলে আপনি নিজে মেনশন করতে পারেন না কোর্টে।
Lordship, I am appearing on his behalf and I
Then you mention. Why are you
have
pushing
handed
him?
over the mentioning slip as addicted.
Very well, that's sufficient. আপনি বলুন কি বলুন?
বলছি আমার আর্জেন্সি আছে, 5 বছর যাবত বন্ধ আছে রাইস মিল, লেবার আছে, আমরা 4
আমি
ভাই
শুনেছি।
বোনেরা খেতে পাচ্ছি না আমরা এরকম।
Yes. বলুন।
হিয়ারিং এর জন্য বলছিলাম স্যার।
আপনার উকিল বাবু মেনশন করেছেন তো, আবার কি হলো?
বলছেন তো আপনার উকিল মেনশন করেছে, আপনি আবার কেন বিরক্ত করছেন?
এটা কি ফ্রি ফর অল একটা গেম? আপনার লয়ার মেনশন করেছেন, প্লিজ গো আউট অফ দ্য কোর্ট রুম, প্লিজ গো আউট অফ দ্য কোর্ট রুম। সবকিছুর ডেকোরাম আছে। কি বলছেন বলুন, মাইক নিন, মাইকটা নিয়ে বলুন।
আপনি যে অর্ডারটা দিয়েছিলেন ওই তারিখে 29/8,
মনে নেই কি অর্ডার দিয়েছেন তো কি হয়েছে তারপর?
সেই অর্ডারটা মানছে না স্যার, আবার আমি রেজিস্ট্রি মারফত দিয়ে
কন্টেম্পট অ্যাপ্লিকেশন ফাইল করতে আপনার কে উকিল বাবু ছিলেন?
ওই তোমার ইয়ে মকারব হোসেন আর সন্দীপন মাই,
উকিল বাবুর কাছে যান, আপনি নিজে আসছেন কেন?
আবার কন্টামি করবো?
উকিল বাবুকে গিয়ে জিজ্ঞেস করুন, উনি বলে দেবেন। কোর্টটা কি আপনাকে অ্যাডভাইস করার জায়গা? এটা কি উকিলের চেম্বার মনে হচ্ছে আপনার? Yes, I've taken sufficient mention. It's now call,
May I be permitted to mention for non-prosecution, my lord?
call on the list, please.
My lord, non-prosecution.
These are 51 matters, my lord, which have become infructuous matters.
Yes, call on the matter.
সার্কিট বেঞ্চ ম্যাটার
জলপাইগুড়ি সার্কিট বেঞ্চ বলো, তুই নতুন কিছু শিখবে? পোর্ট ব্লেয়ার, জলপাইগুড়ি দুটো
পোর্ট
সার্কিট
ব্লেয়ার
বেঞ্চ তো
পোর্ট
আমাদের।
ব্লেয়ার আন্দামান ম্যাটার আইটেম নাম্বার 1
May I be permitted to mention?
No. Yes, Andaman matter, who is appearing? কেউ আছে অনলাইন? বলো, একটু হেল্প করো, তুমি তো নিজের মতো কাজ করে যাচ্ছ। কোর্টটা কোঅর্ডিনেট করো, আমি কি তোমার কাজও করে দেবো? সেটা তো বলতে হবে আমাকে, আমি কি হাঁ করে বসে থাকবো কল করে? অনলাইন কেউ আছে? None appears at the time of call. Let the matter appear next Monday under the same heading. Next. টাইম দিয়ে দেবে 10:30 পরে মন্ডে।
অ্যাপিলেট সাইড ফর জাজমেন্ট আইটেম নাম্বার 1
Accordingly, WPA 14447 of 2023 is dismissed on contest without any orders to cost. Sorry, Dr. Shaha. Urgent certified copies, if applied for, be issued to the parties. It will be on the website today itself so that you can prefer an appeal.
Okay, grateful.
হ্যাঁ, মঙ্গল করে। তাহলে নেক্সট আগেরটা, হ্যাঁ ঠিক আছে, টিউজডে দিবে। নেক্সট কল।
ফর জাজমেন্ট আইটেম নাম্বার 2
I'm for the petition on
Accordingly, WPA 23205 of 2023 is allowed, thereby setting aside the communication dated September 18, 2023, with a memo number such and such, whereby the petitioner number 1 was held to be ineligible. Vacating application is also disposed of accordingly. Respondent numbers 1 to 3 are directed to reopen the tender process from the financial bid stage, deeming the petitioner to be a technically eligible bidder. All consequential action taken by the respondent numbers 1 to 3 in terms of the impugned rejection of the bid of the petitioner number 1 are hereby set aside. The respondent numbers 1 to 3 shall now resume the tender process from the financial bid stage and proceed with the tender accordingly as expeditiously as possible. No orders to cause urgent settlement.
Extremely grateful.
Thank you.
Union of India.
টু বি মেনশন আইটেম নাম্বার
Thank you.
3
Bank of India.
আপনি কি বলছিলেন, কি কারেকশন?
ওখানে রেসপন্ডেন্ট নাম্বার 5 করে ওই রেজিস্টার ডিআরএটির এটা দিতে হবে ওইটা। আর লর্ডশিপ কালকে যে আপনি অর্ডারটা দিয়েছিলেন এই অর্ডারে 4 নম্বর,
বাই ডাইরেক্টিং দ্য ডিআরএটি কলকাতা তো বলা আছে।
হ্যাঁ 4 নম্বর, 4 নম্বর প্যারাগ্রাফ আর 5 নম্বর, এই যে 4 নম্বর প্যারাগ্রাফ আর 5 নম্বর প্যারাগ্রাফে ডিআরটি হয়ে গেছে।
আচ্ছা, ওটা ডিআরএটি হবে।
ডিআরএটি
আর হোয়াট ইজ আদার?
আর কিছু নেই, 4 নম্বর আর 5 নম্বর দুটোতেই আছে।
রাইট। The petition.
Mr. Billodal Bhattacharya and Tapan Bhanji are appearing.
Yes, yes, sir. They're in court. They're in court, Mr. Das. Are they in court?
Yes.
That is the only thing which is to be. Very. The petitioner appearing in person rightly points out that in paragraph numbers 4 and 5, the expression within double inverted DRT double inverted clause is appearing erroneously in place of within double inverted DRAT double inverted clause full stop. Accordingly, in the said paragraphs, comma, it is deemed that the expression DRT be read as DRAT, and this order be deemed to be a part of this order dated November 17, 2023. Thank you.
আর লিখবো না ওখানে,
কোনখানে? এখানে কিছু লিখতে হয় না।
ও আচ্ছা
ওটা আরেকটা অর্ডার হবে, ওটাকে ডিম করা হবে যেটা পার্ট, ওটা দুটো একসঙ্গে সার্টিফাইড কপি তুলে।
আচ্ছা।
টপ আইটেম 4
Lord, I beg to appeal for the petitioner, my lord. And I apologize for appearing virtually, my lord. I have some personal difficulties.
No, nowadays, if you appear personally, physically, then you have to apologize.
My lord, on the last occasion, my lord, kindly sees that the order dated 10th of October, whereby the postal department was supposed to file a report as regards to who is the appropriate authority who will
Yeah.
disperse my duplicate certificates, my lord.
Yes, Mr. Dasgupta, please.
My lord, the report in original is not with me. They had sent by mail, my lord. The officer who was looking
So
after
these
it.
are printout from the mail.
Yes,
I can take that on record.
my lord. My lord,
Yes.
I have talked to the learned advocate appearing for the petitioner. There was a request by the department to file proper for application in the actual format, my lord. That he
I'll give them leave to do that.
they have done my
I have run. We have, in the meantime, we have filed the indemnity bonds and other requirements we have fulfilled, my lord. Let the direction be there to release the certificates.
within a certain time. Otherwise, my lord, they will drag on.
Which respondent should I direct, Mr. Dasgupta?
My lord, it is possibly written in the letter. It is
Acha.
possibly written in the report, my lord. The person who is issuing this letter is possibly responsible.
Superintendent of Post Offices, Baripur Division.
My-
So it is not the South Presidency Division. Respondent of 4 is Superintendent of Post Offices. North
No,
and there are
3,
two.
my lord. 3, my lord, is the South Presidency at Baripur.
My lord, possibly.
Yes. South Presidency, right. Very well. A printout of the email instructions filed by learned counsel for the respondents today be kept on record. Full stop. It transpires therefrom that a fair stand has been taken by the respondents. Full stop. It has been indicated that the respondent number 3 is the appropriate authority to accord necessary sanction for issuance of the duplicates, and the respondent number 7, that is the postmaster, Baripur head office, will issue the duplicates. Full stop. Accordingly, comma, the matter does not remain adversarial as such. Full stop. Keeping on record the written instructions filed by the respondents, WPA 15500 of 2023 is disposed of by directing the respondent number 3 to accord necessary sanction for issuance of the duplicates of the documents in question to the petitioner as early as possible, comma, preferably within a fortnight from date. Full stop. The respondent number 7 shall thereafter, comma, within a further fortnight, comma, issue such duplicates to the petitioner. Full stop. The parties shall act on the server copy of this order without insisting upon prior production of a certified copy for compliance. No address to cause urgency. Thank you very much, both of you.
I'm grateful, my lord.
Thank you, Mr. Dasgupta. Fair enough.
Top item, item 5.
My lord, I'm for the petitioner.
Yes.
My lord, if your lordship kindly consider lordship's last order dated 6th of October 2023.
Right.
Lordship kindly come, paragraph 5 of your lordship's order. My lord, this is the case that the petitioner, sole proprietor, being the supplier of all the computer apparatus, desktop, laptop during the COVID period in terms of the work order issued by the respondent number 2. Now, my lord, respondent on the last occasion on 6th of October, when the matter was taken into consideration, lordship was pleased to direct us to supply a details bill according to the invoice, according to the work order dated item wise. And lordship was pleased to direct us to submit the said copy of the bill.
Have you done that, Mr. Chattopadhyay?
Lordship.
Yes.
Lord, I am very much sorry it has not been stitched.
খেয়াল রাখবে কি দিচ্ছেন অ্যাডভোকেট তুই সাক্ষণ এদিকে
Mr. Wasim Ahmed.
Yes, he was. Mr. Chattopadhyay, I'll give them a last chance. It will
Lordship.
appear as to be mentioned on Wednesday. Please give them a notice. I'll put that in my order.
Lordship.
If they don't refute, then I'll have to direct them to pay.
As well, Lordship.
As per previous direction dated October 6, 2023, the petitioner has handed over fresh bills with requisite calculations to the respondents. Full stop. A receipt in that regard filed today be kept on record. Stop. Next para. However, unfortunately, none appears for the state today when the matter is called on for hearing to refute the fresh bills handed over by the petitioner. Full stop. Next para. As a last chance to the respondents to controvert the said bills, and make their submissions, the matter is adjourned till November 22, 2023, when it will be listed under the heading to be mentioned. First up, it is made clear that if the state is not represented on the said date as well, ex parte orders may be passed in the absence of the state. Will be mentioned on Wednesday.
23rd.
Right, 23rd. 22nd.
Sorry, 22nd.
22nd, not
22nd.
23rd.
Yes.
Upgraded matter, item 6.
For the petitioner, Your
Yes,
Lordship.
please. 14, section 14.
Yes, Your Lordship is pending since 2019, Your Lordship.
Nothing
September.
pending before the
No, Your Lordship.
stated in the
No,
application.
because it's an old matter filed in 2021.
I'll record your submission on that.
Yes, Your Lordship. As within our knowledge, nothing. there is
Learned
no-
counsel for the petitioner bank submits that to the best of the petitioner's knowledge, no proceeding has been preferred before the debts recovery tribunal at any point of time by the private respondent stroke borrower. Full stop. The petitioner bank's application under section 14 of the SABYASACHI Act is pending inordinately, beyond the outer statutory limit. Full stop. The affidavit of service filed today be kept on record. None appears for the respondents for which the matter is taken up for hearing ex parte. WPA 13539 of 2021 is disposed of by directing the debts recovery the respondent number 2, that is the district magistrate at Paschim Medinipur to dispose of the petitioner bank's application under section 14 of the SABYASACHI Act pending against the private respondents as expeditiously as possible, positively within December 8, 2023. No orders to cause, urgent certified copy. The parties shall act on the server copy of this order.
Item 7.
May it please your Lordship, Lord.
Your Lordship,
Yes.
Mr. Devnath Ghosh is appearing on behalf of the respondent. Devnath Ghosh, Your Lordship, is appearing on behalf of the respondents. I'm seeking for a short pass over, Your
No
Lordship.
pass over. Seventh
Lord,
item of the day, no. Yes.
The order that I am asking for today, perhaps they would not, Lord, disagree
Application
with me.
for appropriate orders by you.
Yes, there is an application. I tell you, Lordship, what happened here.
Yes.
Lord, I was allotted a project for Lord excavation of coal.
No, he has started. Yes, please continue. Please continue.
So, Lord, that tender.
Yes.
Wait, wait, adjournment you have. So, Lord, I was doing the work. Lord, there were a lot of hindrances. The work got delayed due to that.
Yes.
They, Lord, wanted to terminate me. I came to your Lordship's court, Lord, challenging that. Your Lordship's, Lord, in the earlier round of writ petition, protected my right, Lord, vis-a-vis the termination and invocation of bank guarantee. Therefore, the ECL filed an application in that writ petition saying that since we have abandoned the work, they should be allowed to continue or get the work done by a third party, invoking clause 10 of the NIT. Your Lordship was pleased to observe that since your Lordship has not injuncted them, they are free if they are entitled to. Those are part of this record. Now, thereafter, they floated a further NIT to get the remaining job done by a third party at my risk and cost without making, Lord, a measurement in terms of clause 10. So I challenge that particular NIT in this writ petition. But Justice Bhattacharya, Lord, at the motion stage, her ladyship, Lord, was pleased to direct the parties, Lord, to go and get one, Lord, measurement done. And, Lord, thereafter, Lord, to file a report, thereafter the matter is coming before your Lordship. Lord, what I am, Lord, submitting before your Lordship that this writ petition may be taken up with the main writ petition because both will be, Lord, depending on each other. Lord, the other writ petition affidavits are complete. If my Lord gives us some time on any particular day, Lord, we can come, their affidavits are complete in that matter, because my main grievance with regard to non-payment of my bills and how much that they would not risk and cost amount, both has to be heard together. And no affidavit has been filed in this matter
This
because
application, this writ petition along with the other writ petition shall appear
There
together.
was some directions of filing affidavits, gives me shortest possible time, I will file it.
my lord may
Regarding this, there was any direction? This
No,
writ
no,
petition
no,
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 there is no
shall give the
direction. I
direction.
have complied with Justice Bhattacharya's
The
order.
previous writ petition, there were directions for.
affidavits are
Yes,
complete.
we have filed opposition.
Mr.
We have
Arjun
also filed.
was opposing this prayer. Yes.
No, I don't understand that he will ask for this, but I thought he will ask.
Lord, he thought that I will not. Right.
No. Today, my lord.
Anyway,
Lord, he was my chambermate, Lord, and he could not trust on me.
the training
I
is
will-
very. The training is very effective, Mr. Chaudhary. Your training is very effective.
Lord, shortest time to file affidavit in this,
Shortest means tomorrow.
maybe 1 or 2 weeks, Lord, and club both the matters together so that it could appear.
একটা কাগজ দিয়ে দাও ওনাকে পেন দিয়ে দাও write the order I'll sign.
But
You're
I can
fixing
only
everything. What
pray-
remains?
I can only
Give
pray
me
for
that.
that. I
What
can
is
only-
the time?
I can only
1 or
pray
2 weeks. Mr. Ghosh is not saying anything. You are only saying so.
for-
No, I
2 weeks for opposition. Very well. Learned counsel for the parties content that the outcome of this writ petition is intertwined with that of WPA. What is the other number? ওটা other numberটা দিয়ে দেবেন।
I have given the number.
ওই নাম্বারটা দিয়ে দেবেন নি। Push up. Accordingly, the respondents are directed to file their affidavits in WPA 28519 of 2022 within a fortnight from date. Push up reply, if any, shall be filed within a week thereafter.
ঠিক আছে একসঙ্গে করে দিও
WPA 28519 of 2022 along with the connected can bearing can 1 of 2023 shall be listed along with the other writ petition bearing WPA numbers such and such on December 11, 2023 for hearing.
But I'm grateful to
Great.
you. Lord, under the same heading it will appear. Under the same- দুটোই তো একসাথে tag হয়ে গেছে। Lord, one more prayer. Lord, in this writ petition, they have issued, Lord, letter of intent to a third party. Although I have not made any prayer against him, Lord, should I add him up? But my Lord may grant me leave because he might be affected in future. Kindly allow me and serve him and come back. He will also file affidavit.
আরেকটা লাইন অ্যাড করে দেবেন মাধববাবু on the prayer of learned counsel for the writ petitioner the writ petitioner is granted leave to implead a third party according to the writ petitioner in favor of whom a letter of intent has been issued. First up, necessary consequential corrections shall be carried out in the cause title of the writ petition during the course of the day, and a copy of the corrected writ petition be served on the added party, on the proposed added party at the earliest, and an affidavit of service to that effect shall be filed on the next date of it.
আজকেই করে দেবেন।
এখনই করে দিচ্ছি।
8 নম্বর ভুল আছে মানে অন্য নাম্বার এসছে ডাকতে তো হবে লিস্টে
Item 8.
it is wrongly appearing.
My lord, actually, it is a change brief and Mr. Joy Gupta was previously there. My lord, 1 week time may be given so that.
No, this is appearing wrongly বললে তুমি you are appearing in which item? The one which is appearing?
Yes.
এটা কি
But
আমার
I
determination
do not
আছে
have the brief with me.
জানো আমার ফাইলটা নেই
এটা এডুকেশন ম্যাটার তো লংলি চলে
this is erroneously appearing. This matter is erroneously appearing. I cannot pass any order also. So this will go out of the list.
That will
The
go out of the-
actual matter which was mentioned that will appear tomorrow.
Yes.
The matter
Stick to
relates to
my-
education. Well, that's why I was
In it.
perplexed to a certain extent.
Nowadays I am not perplexed because that's the usual thing in my court. Yes.
Item 9.
My lord, I am.
You are for the petition. Mr. Pal, you are for the bank.
Yes, I am for the bank.
Yes, Mr. Watson.
Milord, I made an application for a one-time settlement before the authority in respect of the loan which was given to me. Now, the OTS is pending. I made an application before the Learned Debts Recovery Tribunal 2. The matter has not been taken up.
Because it is not in season.
And the reason which I know, my lord, is that functioning of the Debts Recovery Tribunal 2 is
My
not
lord, sorry to intervene, my lord. the application filed before Debt Recovery Tribunal 3, not 2. And 3 is
Three is now functioning.
3 is very much functioning regularly.
Page
এটা কোন
30
matter? কৃষ্ণচন্দ্র ধর।
Krishnachandra Dhar, yes.
কোন matter আছে?
বিজয়
না, না।
এটা না তুমি আমাকে তো মানে
This is not your matter at all.
No. That is why I was surprised.
no, sorry.
Oh, it's all right. It's all right.
Kaushik Das is appearing for the
Yes, my lord. Your lordship can remember, my lord, several times it appeared previously, and your lordship directed me to give notice. My lord, accordingly, I have given notice, but still he is not
Very well, I'll
answering.
dismiss the matter for default. Despite notice, none appears for the petitioner at the time of call. Full stop. Next para. A receipt in that regard filed today by learned counsel for the bank be kept on record. Full stop. It appears from the order sheet of the present writ petition that the petitioner has remained absent on almost all the occasions when the matter was called on for hearing. Full stop. Hence, it transpires that the petitioner is no longer interested to proceed with the matter. Accordingly, WPA 6628 of 2023 is dismissed for default without any order as to cost. Interim order, if any, stands vacated.
My lord, it may be passed on merit. My lord, there is
No merit.
my lord, there is a grievance. He has filed essay before debt recovery.
Sapal, there are certain judgments that in the absence of the, we know that in the absence of the petitioner, merits on merits we can.
But it may happen somewhere in future. He may file restoration application. Again, bank have to suffer all these things. There is nothing, no merit actually. Much obliged.
Thank you.
Item 10.
I persuaded my learned friend. I am enjoying an interim order, but I am paying 1 day's apology. I cannot, my lord, make myself rich. Mr. Panja is there. I have persuaded him, subject to my lord's pleasure.
Yes. So what? Have you been persuaded properly?
I do not know the implication of that. But
no other implication. I mean,
I'm
are you
saying-
persuaded? Are you agreeing to that? That is the only
The only thing, that's why I said I am told when next time probably.
You agree or not to that? If you don't agree, I'll take
Only
up.
1 day, but no, so all right, but subject to the next time when the matter will appear, please lord to direct to appear top of the list, because I am told appearing in the list.
No, it will retain its position in the list wherever it is.
No.
এটা সিরিয়ালি অরিত্র সিরিয়ালি এটা লিস্টে যেরকম আছে সেরকম থাকবে
এই জয়েন্টারটা কি ফাইল করে দেবো
না
আপডেটের তলায় পাঠিয়ে দিও না যেরকম আছে এই জায়গাতেই থাকবে পর অন্যগুলো
He will be prejudiced at my instance.
On the prayer of learned senior counsel appearing for the petitioners, the matter is adjourned for the day and shall next be listed on November 22, 2023. Full stop, the matter will retain its position in the list.
Item 11.
Yes.
But for item 11, I'm praying for 1 week time. My lord, advocate on record, Nomita Basu is seriously ill.
No, in upgraded matters, I don't grant time. Then it moves down the list.
There is an interim order that is subsisting. My lord, I am for the state although nothing much to.
Interim order, no. In upgraded matter, no time. You have to move the matter.
My lord, I am not having the brief, man. I am just.
Interim order is till when?
Till today, lord. 30th, my lord.
That goes.
My lord, next week is not within 30.
An adjournment is sought on behalf of the petitioners when the matter is called on for hearing. Full stop. Next para. Accordingly, let the matter stand adjourned for the day. Full stop. However, comma, the matter shall now be placed in the list under the regular heading and not under the heading upgraded matters. Full stop. I'll extend for a limited period. The interim order granted earlier is extended till November 30, 2023 or until further order, whichever is earlier. 30th November. Protect to need.
Item 12.
Well, my lord, I am for the petitioner.
Yes, what is it?
My lord, may kindly come to page number 20. This affidavit service.
All have been served.
My lord.
But I am appealing for the Union of India.
Union of India is the main party, no?
No.
I am for the respond number 4 and 5. I see.
Bank. Well, yes.
Madam, kindly come to page 20.
20, yes.
But my account has been freezed in the year 2022 with a reference given there at first paragraph, last line. Now, my lord, thereafter, I have written letter to bank to give me 4 details so that I can contact the concerned department with respect to pendency of case. Now, in all different type of manners, the bank is in habit of just getting a notice from the concerned department and used to freeze the account. I am merely a shopkeeper. I am running a shop. But who has said me payment? But it is not
But the
clear.
details have been given here.
Only number is GPN number 229/2021. I have written letter to the ombudsman. I have written letter to the bank that you should collect further information so that my client can contact over this and can get details. Now, this is why I am saying this matter. In criminal matter, what usually does, wherever the amount is going, the concerned department is sending notice to the bank and saying that freeze the account. Now, my lord, even if it is true, my account, if it is involved, then my lord, kindly see the date, April 29, 2022, the top letter. Now, from there, investigation must have been moved. There must have been some incriminating materials against me, calling me further in this matter. Now, casually, just accounts are being freezed and they are remaining silent. I am writing letters. He is a shopkeeper, my lord.
Yes, you have to disclose the details of this. What
My lord,
just the Bangalore police has written to you.
The disclose the informations which are available with us that has been provided, my lord. The Mangalore police has,
Just because an investigation is going on, the bank account may not be freezed.
my lord, bank has no interest in freezing the account. The Mangalore police has already given to defreeze the account. That has been done, but there is a lenient pursuant to the direction given by Tamil Nadu police station, and the bank is writing to the Tamil Nadu police, but they have not responded. That we have also
You
mentioned.
impede those parties, the Tamil Nadu police
But
station.
Tamil Nadu-
Mangalore is in Tamil Nadu. Mangalore?
No, my lord, Mangalore.
My lord,
police-
respondent number
Karnataka.
6.
Karnataka.
Respondent number 6 is there. The officer in charge, CN Crime Police Station, Mangalore
So you have to
City.
impede then those authorities.
But I have implemented.
Oh, they are
Respondent number
parties.
6.
Acha.
More particularly, respondent number 6 is there.
Has the respondent 6 been served? Just check up.
My lord, may I check?
Just check up. It to the
service.
Please check up.
No, item dispatched is written.
My lord, Mangalore city, that they have asked to defreeze. That we are doing. The Tamil Nadu police has to be added, my lord, because a lien pursuant to
You have
their
not
order
written
is.
anything regarding that to them.
Yes, your
What is
lordship.
that?
Yes, in this letter, both Tamil Nadu and Mangalore both have been mentioned, my lord.
In the letter
That-
which
which
has
is
been
also
annexed.
yes, they have annexed. That is of 29.
Out of Shraddha. Refer to the annexed to the annexure. Come to page 20
Yes,
of the
yes, my lord.
petition.
Page number
You don't have a copy of the
20,
petition.
20, your lordship.
Come
Both,
there. Where
it
is
has been mentioned about both.
the
my-
last paragraph?
The first paragraph itself.
Tamil Nadu is first paragraph itself.
The second paragraph, my lord. The
Acha.
bank is in receipt of direction issued by Inspector of Police, State Cybercrime Cell, Tamil Nadu towards this. So they have to implement Tamil Nadu.
Implead that party also. You have implemented only
I
Mangalore.
will do, my lord, but I am showing, my lord, this is applicable.
No, there may be something serious.
My lord. That is why, my lord, I am saying if there is something serious, then April 2020.
Implead Tamil Nadu police.
But I will
Bank may not know.
But I will implicate.
The petitioner's grievance is that the respondent ICICI Bank has frozen the account of the petitioner apparently on intimations by the Cybercrime Cell Tamil Nadu and the Mangalore City Police Station. Full stop, next para. Although the Mangalore City CEN Crime Police Station has been impleaded and served, comma, the State Cybercrime Cell, comma, Tamil Nadu has not been impleaded. Full stop. Since the bank submits that it is ignorant of the details of the investigation and the stage thereof, comma, the Inspector of Police, comma, State Cybercrime Cell, comma, Tamil Nadu is a necessary party, comma, whose presence is required to explain the stage of the investigation and as to why the bank account of the petitioner in Kolkata was frozen. Full stop. Accordingly, the petitioner is directed to implead the said inspector as a party to the writ petition. Full stop. Necessary consequential correction in that regard shall be carried out by the learned advocate on record for the petitioner by November 22, 2023, because you'll have to take instruction as to the address from the internet. Just take by November 22, 2023. Full stop. A copy of the writ petition shall be served on the added respondent at the earliest, and an affidavit of service shall be filed on the next returnable date. Full stop. The matter shall be listed on December 5, 2023 next under the heading upgraded matters.
Deeply obliged.
Thank
My lord, only one thing. My lord, may I be given liberty to serve also through email? Because only email I'm getting. If I
have not specified the mode of service.
My lord.
But it would be better if you serve
I
by
will search
both
over the
by
net.
both
I will
modes.
search
Yes.
over the net.
Both modes.
Net search for anything.
Thank you.
13.
13, my lord, same matter. This is in respect of different bank. There, my lord, I have made respondent number.
Bank is not a I'm for the union.
You are for the
Union of India. Union of India.
union.
There is the concern letter is page 19. There, my lord, I am getting only one reference that have been made as party respondent number 6, affidavit service.
Good service.
My lord, I'm looking just.
Check up. That is the most important.
That is important. My lord, dispatched. Page 19, my lord, only one reference I'm getting.
Dispatched is not good service. Not yet. When did you send? 12th
Long
of
back.
October.
Long back.
Not. Yes, long back.
Long back, my lord.
Serve again.
My lord.
The petitioner's grievance is that the respondent bank has frozen the account of the petitioner at the behest of the Cybercrime Police Station, Vijayawada City. Full stop, next para. Although the officer in charge of the said police station has been impleaded as respondent number 6, it transpires from the affidavit of service which is filed in court today and kept on record that the said respondent has not yet been served properly. Full stop. Accordingly, the petitioner is directed to serve afresh on respondent number 6, intimating that the matter shall next be listed on December 5, 2023 under the heading upgraded matters when a further affidavit of service in that regard shall be filed by the petitioner.
Highly obliged, Lord.
Try to serve properly so that they are represented at least.
14.
Lord, I appear on behalf of the petition.
Yes, Mr. Bhattacharya, what is the matter? That bank. This is the
That
DRT2.
matter wherein I made a mistake.
DRT2 is
Lord,
not functioning.
Yes, and that's the reason I have come and I have found, my lord, that my learned friend had appeared in a matter wherein your lordship passed this order. But I extra copy it.
This proper service has been effected on the respondent.
Lord, that's what I wanted to ascertain for my not. Lord, kindly do not take up the matter.
No, let me see if what was directed last time. Oh, an interim order was passed also. So till when shall we wait? When did you send?
Long 10th.
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 10th of October or November?
No, 10th of October.
Serve afresh, I'll direct you to serve afresh. You can serve by any mode, personal service or whatever.
When we made this with
No, yes,
Mr. Bhattacharya Mala, when we prepared this, it was dispatched. Now it is showing it's delivered.
So file a proper affidavit of service on Wednesday. I'll keep it under the same heading.
Grateful.
Let the matter stand adjourned for the day to enable learned counsel for the petitioner to affirm a proper affidavit of service, including all current details.
I'm grateful.
File that and please keep this with you.
Yes.
Mr. Dhorke, just hand it over or when I take it up next.
15.
15, I am for the petitioner.
Yes.
I have the instructions to appear on behalf of the respondents. But I'm praying for a week's time or in the I've spoken to my learned
says
friend
that he has yet to receive the brief. my lord.
because I'm
So,
intervening holiday. Even today is board offices.
my lord, we both propose first week of December, my lord.
Very
In the meantime, I believe he will be.
In the meantime, I will get it with the instruction.
Very well. On the prayer of learned counsel for the parties to enable the respondents to take proper instructions, let the matter stand adjourned till December 5, 2023, when it will be listed under the same heading.
Let it retain its position as an upgraded
Same
matter.
heading. Same
Yes,
heading.
16. Lordship, I am appearing on behalf of the petitioner.
Yes.
Your Lordship.
I attend for Reserve Bank.
Yes.
I am for Union of India, my lord.
You are there on,
Respondent number 1.
you are there on Saturday also.
Yes, Your Lordship.
Right. What is the matter?
Lordship, the petitioner
এই
is
মাইক্রোফোনটা না
the
আছে ওই ওনার মাইক্রোফোনটা একটু আস্তে করে দাও কান ঝালাপালা হয়ে যাচ্ছে ইয়েস
the petitioner is the younger brother.
Microphone is much shorter than you. Take it up. Younger brother of?
Younger brother of the deceased, Your Lordship. The husband and the wife. The husband, they got married on the year 2015. Thereafter, the wife passes away on unnatural death. The petitioner prefers the criminal case before the learned.
You're the brother of the wife?
Yes. The petitioner prefers a criminal case under 304B at 498A before the 3rd Additional Metropolitan Magistrate, Hyderabad.
Yes.
Thereafter, the brother gets acquittal. I mean, the husband gets acquittal. Thereafter, they prefer an appeal. The brother prefers an appeal before the Telangana High Court, and the appeal is still.
State prefers the appeal?
No, Your Lordship. The brother.
You?
Has
you prefer?
I prefer. The brother prefers an
appeal. The complainant.
Yes.
De facto. Yeah.
They prefer an appeal, and the appeal is still pending. And now the husband claims employees' benefits for his late wife. The late wife was a assistant manager of RBI Hyderabad. So now RBI comes up with a notice stating, Lordship, the notice is at page number 37. 3 notices were served stating that if an order from the competent court is not passed, then they'll disburse the fund, the employees' benefits fund.
You don't have any locus standi.
He should file before the Hyderabad.
No, even then, even if you file before Hyderabad court, how can you resist that?
Yes. Because
Lordship, I am resident of Kolkata.
Yes.
My sister was a resident of Kolkata.
No,
even the husband is a resident of Kolkata. They only went to Hyderabad for work purposes.
She was working.
So,
no, I'm not saying that this court does not have territorial jurisdiction because the account is in Kolkata.
No, Your Lord.
You worked in Kolkata or
No, Hyderabad.
She worked in Hyderabad.
He was in Hyderabad. I have received it.
But my client received the notice in Kolkata.
Now, how can you resist even? I mean, what is your right to resist the money from being disbursed to the
Lordship? The thing
on
is,
merits also you don't have a case.
Lordship, the criminal case is pending. If I may refer to your.
He has been acquitted by one forum. Yes. As of today, he is standing acquitted.
Acquitted.
Your appeal is only pending.
Your Lordship, the appeal is pending, Your Lordship. It is a continuation of that.
Does he automatically get, cut off from the wife's pension or whatever?
No, Your Lordship. I am referring to All India Services Death Cum Retirement Benefit Rules, Your Lordship,
yes.
1958. Lordship, if Your Lordship comes to the last page, Your Lordship, it falls under Rule 22, Sub-Rule 17A.
Yes.
17A. Kindly reads, if I may be permitted to read, Your Lordship.
Please.
If a person who, in the event of death of a member of service, while in service is eligible to receive family pension under this rule, is charged with the offense of murdering the member of service or for abetting in the commission of such an offense, the claim of such a person, including other eligible members or members of the family to receive the family pension, shall remain suspended till the conclusion of the criminal proceeding instigated against him.
You appeal the continuation of the proceeding?
Yes, Your Lordship.
Now satisfy me on territorial jurisdiction.
Lordship, in that prospect, I am referring to one of the judgments.
Now tell me what happened here. You are reciting that is immaterial basically because your residence here, you received something here, you are saying?
Yes, Your Lordship.
Received what?
I received the notice from the RBI.
Saying?
Saying that if you don't get an order from the competent jurisdiction, competent forum.
That notice was a reply to your query. You probably wrote to the RBI.
No, Your Lordship. I did not write anything.
Achha, what is that notice?
Page number 37, Your Lordship.
Of their own, they wrote this?
Yes.
No, this was written to Bina Jain. Who is Bina Jain?
Beena Jain is my mother.
So what is your locus standi?
Lordship, the first notice, Pankaj Jain, he's the petitioner, your Lordship.
You are showing page 37.
Yes, your Lordship.
That has been addressed to Bina Jain. Your name is not there. You are nowhere in this.
Your Lordship, there are 3 notices, your Lordship.
First notice,
Oh, second notice, page 38 is yours.
38 is mine, your Lordship.
So you are otherwise the heirs if he does not
Yes,
get.
yes, your Lordship.
That's right.
Lordship, I am only praying for a stay on the order till the...
No, first on the territorial jurisdiction.
Yes.
So you received the notice here.
I received the notice here.
But the account is in Hyderabad.
The account is in Hyderabad.
She worked in Hyderabad.
She worked in
Her
Hyderabad.
pension became due in Hyderabad. Everything is there.
Yes. The criminal proceeding is pending before Lordship. Then
That's also in Hyderabad.
That's also in Hyderabad, your Lordship. Lordship, I'm referring to this judgment of the Supreme Court, your Lordship. Lordship, in this
part of the cause of action.
Yes.
That is 226(2).
Yes, and also section 20 of CPC, your Lordship.
20 is always there, yes. But what part of the cause of action arose here?
Lordship, in this Lordship item paragraph number 3.
You are trying to restrain the money from being disbursed to somebody,
Yes,
to her husband, your brother-in-law.
Yes.
Now the disbursal is in connection with a service which she did in Hyderabad.
Yes, your Lordship.
Her place of service was in Hyderabad.
Yes.
Pension got accrued to her in Hyderabad.
Yes.
If somebody gets, it will be disbursed from Hyderabad also. Criminal case is also on Hyderabad. Only by virtue of a notice, I mean, it does not even create a cause of action. I mean, this is not one of the bundle of facts which give rise to the cause of action.
Lordship,
You just received the notice here.
I just received the notice here.
Look, Hyderabad actually, we do not have jurisdiction, territorial jurisdiction. Everything arose in Hyderabad. Your friend is correct on that.
Lordship, but I was residing out here and the notice was sent to me. On that prospect, your Lordship,
If the cause of action was that you are entitled to something, because here your entitlement is dependent on the husband's disentitlement.
Yes, your Lordship.
The cause of action arises in respect of his disentitlement. The bank even wrote to you that in the absence of any order, we will disburse to him. The relief you are seeking is don't disburse to him. So,
Lordship,
husband resides where? There.
Yes. Husband is presently residing, but they are even residents of Kolkata, your Lordship, because I have sent them the petition in Kharagpur address.
What do you say? Yes.
What it fell from you, let me take instruction because it relates to Hyderabad. Entire record is
No,
in
instruction, argue on law. It is everything is on record. There is no
Yes,
question
my
of any
lord,
instruction.
Your Lordship has gone through the record. So everything happens in Hyderabad.
Yes, what do you say, Mr. Mujumdar?
We have nothing to say, my lord. It is a part of RBI, my lord.
Correct, we have to carry out. Because under the rules, we have to pay to the nominees or the.
Your dog or somebody else's? Mr. Mujumdar, your dog?
Yes, yes, my lord. Sorry.
What breed? Labrador? Yes? Okay, silent করে দিচ্ছ কেন?
No, Beagle, my lord.
Beagle. Well, small dog.
Lordship, if I may, Lordship, if your Lordship kindly comes to the judgment of the Supreme Court, Your Lordship. Paragraph.
No, you have argued very well. I'll hold that we have territorial jurisdiction. So I'll direct, I'll pass an interim order, I'll direct affidavits to be filed. Let them
Yes,
file an
yes,
affidavit.
that will be.
Learned counsel for the petitioner, in his usual eloquence, argues that this court has territorial jurisdiction by placing reliance on Cement Workers Mondal versus such and such, reported at 2019-20 SCC 517, which virtually places stress on Article 226 within bracket 2 of the Constitution of India, to the extent that a part of the cause of action arises here. Full stop. The case pertains to the death benefits of one Srimati. What was your
Shweta Jain.
sister's name? Was Shweta Jain.
Shweta Jain.
One Srimati Shweta Jain, since deceased. Full stop. The petitioner is the brother of the said deceased. Full stop. On the allegation of commission of offence inter alia under section 498 capital A and section 304
B.
304 capital B of the IPC, a criminal case was registered against the husband of the said deceased, namely Sri Nilesh,
Nitish
Sri Nitin Jain. First up, subsequently, Nitin Jain was acquitted by a criminal court. First up, however, the de facto complainants preferred an appeal, which is now pending. First up, it is contended by learned counsel for the petitioner that in terms of Rule 22 within bracket 17 within bracket small a of the All India Services within bracket death-cum-retirement benefits bracket close rules, 1958, if a person who in the event of death of a member of service while in service is eligible to receive family pension under the rule, is charged with the offense of murdering the member of service, etc., the claim of such person, including other eligible member or members of the family, to receive the family pension shall remain suspended till the conclusion of the criminal proceedings instituted against him. Full stop. Next para. It is contended that in view of such rider, the pendency of the appeal against the acquittal of the husband of the deceased is sufficient bar to release the family pension entitled to be received by the deceased in favor of her husband. Full stop. Next para. The question which arises is whether any part of the cause of action arises within the territorial jurisdiction of this court. Full stop. Next para. It has been pleaded in the writ petition and argued by the petitioner that a notice was received by the petitioner on September 15, 2023, issued by the Reserve Bank of India, which is the employer of the deceased sister of the petitioner, to the effect that the deceased husband of the said the husband of the said deceased has made a claim to the employee benefits of late Srimati Shweta Jain. First up, the bank wrote that in the absence of any order from the court of competent jurisdiction restraining RBI from releasing dues, within a period of 1 month, RBI will be constrained to release the said amount to Sri Nitin Jain. Full stop. Although there is overwhelming circumstances which point to a substantial part of the cause of action arising in Hyderabad, as the deceased was employed in Hyderabad and would be entitled to her family benefits in Hyderabad, as well as the husband of the deceased resides in Hyderabad and the criminal case is pending in Hyderabad, the fact that the cause of action of the present writ petition, insofar as the petitioner is concerned, arose within the territorial jurisdiction of this court, as the intimation regarding the petitioner's right of restraint was served by way of a letter of the RBI in Kolkata, comma, this court is of the opinion that the operation of Article 226 within bracket 2 is very much applicable in the present case, comma, as a part of the cause of action at least arises within the territorial jurisdiction of this court. Full stop. Hence, the writ petition is entertained. Full stop. Next para. The respondents are directed to file their affidavits within December 15, 2023. Full stop. Reply, if any, shall be filed by December 22, 2023. The writ petition shall be listed for hearing in the monthly list of January 2024. Full stop. Next para. Reserve Bank is which respondent? The respondent numbers
3.
Numbers 2 to 6, 2 to 5 remain restrained by an order of injunction from disbursing the benefits accruing to late Shweta Jain, comma, the deceased sister of the petitioner, till January 31, 2023 or until further order, whichever is earlier.
I'm grateful. Thank you.
Next.
Much obliged.
17.
My lord, I am for the WBCD.
WBC.
I'm for the state, my lord.
Although the WBSEDCL and the state are represented through counsel, none appears for the petitioner at the time of call. Full stop. Let the matter stand adjourned for the day and shall now be listed under the regular heading and not under the upgraded matters list. Thanks.
My lord, I'm the petitioner appearing in person.
Yes. What is that?
Yes. In last occasion, my lord, the other side took.
No, you move your matter. Yes.
Yes.
What is your matter?
So may I be permitted to argue for a while? Lordship, the first thing is that the inspection report is it's denied by the concerned railway authority.
What
And
inspection?
the inspection reports. Please come to page number, my lord. 23 of the 22 of the petition. Yes, that is. These are the queries.
Actually, my lord, in this matter, my lord, my learned junior received the instruction yesterday evening, my lord. As because, my lord, the concerned authority was not received the copy. And my lord, I have not yet, my lord.
So what is
able
the
to-
scope of the writ petition? Let us get that first. You asked for an information under the Right to Information Act.
Yes.
What happened after that?
Yes, my lord. First, that I have asked for the footplate inspection report from the Eastern Railway.
Give me the steps. Just what happened.
Yes.
Don't argue the matter now.
Yes.
Then that was given.
No, that was not given. And further that I applied for the before the first appellate authority.
First
appellate authority said
no. The very first authority refused.
No, he didn't refuse.
But
first appellate authority directed the public information officer to furnish the information. Then the public information officer, what is submitted that is a different statement that he will not give the inspection report due to some such and such reason. Then I applied under section 19, clause 2 before the Central Information Commission, New Delhi. So Central Information Commission called for a hearing. The matter was heard, both the parties. And after that, the Central Information Commission passed an impugned judgment.
What instruction do you require?
My lord,
File
that
is with you.
That is the my lord, the footplate inspection. That is a very vital thing for the railway. As because, my lord, in the cabin of the driver.
Argue the matter. Let us hear the matter. This is a short matter in the every matter. By what instruction? Further instruction is required. When was the copy served?
No, my lord. Actually, my lord, instruction was served upon yesterday evening upon my.
That is by your client.
Yes, my lord. Actually, what happened, my lord, the concerned authority, that is the Deputy Chief Operation Manager, he was not served.
Come prepared on Wednesday. On the prayer of the respondents, the matter is adjourned till November 22, 2023, when it will be listed under the same heading. Please come back. This is the last chance to you. Please come prepared.
Grateful, Your Lordship. That's it.
New motion, item 19.
But I am for the petitioner in this matter. I have
Yes.
served, and they are decision finding the abuse service.
You are
A very
appearing.
short
My lord,
matter.
learned ASG is appearing on behalf of the Union of India on virtual mode.
What I am saying. I believe I got a very innocuous prayer. As per the scheme of 1972, the sons in exceptional circumstances is entitled to have the freedom fighters dependent pension. Well, I have annexed the scheme. I will take to that. So my father was granted the pension under the scheme of 72. In 1980, he died. Thereafter, mother was getting the pension, and I was being maintained by the mother. I am a 90% handicapped child of my father. Well, after the death of my mother in 21, well, I have applied in 22. That has not yet been considered.
Mother
So-
was getting the pension.
No,
Mother
mother
was
has died. Mother has died.
Mother
After
was getting the
yes,
pension.
Yes, bro. After the death of my mother, I applied for the dependent pension. That has not yet been considered. So what I am saying, let the writ application be disposed of with a direction to consider my representation at page Miller, at page Miller 26 within certain time, in accordance with law.
Yes, Mr. Chakraborty. Consider,
Yes,
consider and dispose easiest possible.
I have no objection, my lord.
Great. Learned counsel for the petitioner points out that upon the demise of the petitioner's father, who was a freedom fighter, the petitioner's mother had been receiving the freedom fighters pension under the relevant scheme. On the demise of the petitioner's mother in the year 2021, the petitioner, who is a 90% handicapped person, being the son of the freedom fighter, applied for getting such pension in place of his mother. Next para, such representation, it is submitted, is required to be considered by the respondent authorities. Heard learned counsel for the parties, including the learned ASG, in view of the innocuous nature of the prayer, no affidavits are being directed, and it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. WPA 23926 of 2023 is disposed of by directing the respondent authorities to consider and decide on the representation of the petitioner dated February 15, 2023, annexed at page 26 of the writ petition as expeditiously as possible, positively within a month from date, and intimate in writing the outcome of the same to the petitioner. No address to cause urgency. Thank you.
Well, may I just make one prayer?
Yes, Mr. Chakraborty.
Within a month from the date of notice, because I do not know when the learned advocate for the petitioner shall serve.
I
No,
have
you are
directly served to
represented.
author-
You are represented. You are appearing for them.
No, your lordship has said 1 month.
1 month from today.
Very
But you are appearing, Mr. Chakraborty. Yes. Next.
Well, every service be kept.
Today's size file today be kept on.
20.
20, I appear for the respondent number 1, my lord.
I am for the petitioner, not today, my lord.
Why not today?
So senior is engaged in.
No, move that. Where is your beef? Move the matter, move the matter. Take the microphone towards you. Yes, what is the matter about? Who is your senior?
So Devashish Mitra.
Devashish?
Mitra.
Mitra?
Yes.
Move the matter. What relief have you claimed? This is regarding some work done by them for
Work
you.
done, my lord, in the writ petition, my lord, they are asking for money claim.
If it's otherwise not, it is disputed.
Not disputed, my lord. They have kindly come to page 31 of the writ petition, my lord. Page 31.
31, yes.
My lord, kindly come to the terms of payment.
Right.
Payment terms will be back-to-back basis. Payment will be made on receipt of the payment from the relevant customer. Here, my lord, the relevant customer is state of West Bengal. We are also a state of West Bengal, my lord. We are service.
You're Webel.
We are service provider to the state. My lord, we are regularly chasing up for the payment. That is the only.
I'll direct the state to disburse the amount to you within a limited period, their bill
That
amount,
can be done.
and then you will. I'll dispose of the writ petition.
That can be done.
Your senior is in court.
No, sir. He is in Shialda court.
What is your name?
Sir, Priya Chakraborty.
Priya
Chakraborty.
Chakraborty. I'm allowing your application. I'll direct them to pay the money within a limited period.
Well, it will be released by the state.
I'll direct the state first.
Yes, yes. Respondent number 2.
Very. Heard learned counsel for the parties. Full stop. Ms. Priya Chakraborty, appearing for the petitioner, argues that the petitioner did several work for the respondent number 1, but the payment for such work was not disbursed to the petitioner. Full stop. Next para. Although not disputing on merits the claims, comma, learned counsel for the respondent number 1 submits that the respondent number 2, that is the Labor Department of the Government of West Bengal, is required to disburse the due amount to the petitioner, to the respondent number 1 for the purpose of paying the same to the petitioner. Full stop. Next para. None appears at the time of call. Where is your affidavit of service? File it.
Sir, it is not here.
Check up your file whether it is there.
Check up karo, check up karo. Lord, probably it is not ready, my lord. The postal slip is there. My lord, kindly take it up.
Sir, I will.
None appears for the state at the time of call. Full stop. Since no affidavit of service has been prepared as yet by the petitioner, comma, let the matter stand adjourned for the day. Marketer ja ache ache thak. Thank you. You also please take instruction as to, I mean, if somebody is appearing, ask your junior to him.
I'll do that, my lord.
21.
This is my application, my lord.
Yes.
This is my affidavit of.
1 minute. আগেরটায় যেন সিনিয়রের নাম না ঢুকে
My lord, this is my affidavit of service, my lord.
You are?
The respondent number 3.
Private respondent.
3, no, 5. No, my lord, this is a awkward position, my lord. It's a case of, my lord, new electric connection in my premises. What happened, my lord? In a portion of my premises, my father inducted a lady who is estranged from his husband long back, who took the electricity.
Lady who?
Estranged from his wife, my lord, he is deserted from his matrimonial.
How is that material in an electricity?
My lord, no, that is, my lord, I have annexed one document, my lord, where, my lord, she gave an undertaking, whenever he get the accommodation and whenever I require that room, she will vacate. But what happened, my lord? She took the electricity. It's an occupier having no locus. Now, my lord, I have, my lord, paid the quotation amount. My electricity has not been affected due to no new establishment is found. This is the reason, my lord.
My father is the owner of the property.
My father is the owner of the property. I am the, my lord, the
father already has a
father is alive. Father is alive.
No, father already has an electricity meter in his name.
No. There is no electricity initially. Electricity took by that occupier.
What is your locus standi?
My locus
standi. You are a
standi.
licensee of your father.
Yes, my
you are a
father
licensee of your father. She is a licensee of your father. Equal footings.
Yes.
No. My father is giving me permission, my lord. My not licensee, my lord. I am the owner of the property. My lord, I have annexed the, my lord, the
You said your father is the owner?
No, my lord. This is me. I am the owner.
Where is your purchase deed?
My lord, purchase deed is not here, my lord, but page 19, my lord, the Panchat receipt, my lord, the tax receipt in my name. Mutation.
Tax receipt does not confirm.
My lord, deed, my lord. My lord, I am giving it.
Where have you stated that you are the owner?
Yes. Paragraph, my lord. Paragraph 4.
Paragraph 4. Yes, what do you say?
So that he
Only the electricity.
Objector lordship, as and when we are going there,
If they don't object, there is no other hindrance to give electricity to them. You can give electricity connection.
Well, one thing, one instruction I have received.
That one instruction is the most
Well, that is the private respondent number approached before the learned code below under section 144, case number such and such on 9th June for the said property where BLRO and OC Chonditala PS were directed to restrain opposite parties until further order and submit report in this regard.
154 under 154, 144 criminal procedure, criminal code cannot restrain anybody from giving electricity. Only peace, tranquility.
Lordship.
Yes, what do you say?
Your Lordship, I just have received this brief today morning and I have not yet filed my Vokalatama. Kindly allow me time for next for filing Vokalatama
No.
because I'm not ready, Your Lordship.
Vokalatama, you find I'll give you liberty to file by Wednesday.
Bye, Your Lordship.
I'll dispose of the writ petition right now. What is your defense?
Actually, my defense is
Why you
that
objecting to the
I am challenging the maintainability of this writ petition because this is a Khatian 1 number plot and the petitioner is not at all the position holder and owner of this property because it's a khas jami land and the collector of the government of West Bengal is the one.
Who are you?
I am the possessor.
In what capacity?
In what capacity I am giving the rent to the and property tax to the panchayat and panchayat allowed me.
You are objecting that he is at all an occupier of the premises?
Yes. By way of a simple 10 rupees 10 paper, there's a live-in license, not an agreement, there's a declaration.
Page 22.
What declaration?
And that I am challenging.
Hard declaration.
Without my
Hard
consent,
declaration.
I am a lady with a layman and not reading, I am reading to English.
It's in Bengali.
Page 22.
Annexure P2, my lord.
Where is the declaration?
Ami Hira Begum, Aadhaar number such and such.
Stamp paper. Stamp paper যেটা রয়েছে।
You said that you are disputing some page 22 document.
Page 22, he said.
Yes, I have annexed, my lord.
Page 22 is something else. You don't have a copy of the writ petition?
No, I just received.
Page 20.
If your lordship permit me, I will annex the all document relevance for my defense in the event of opposition or the challenging.
Question of opposition in electricity matter. Yes, what proof of occupation you have annexed?
I am annexed, my lord, the panchayat tax receipt in the name of my lord the petitioner, and then my lord
I'll direct electricity to be given to him. You are enjoying electricity there.
Yes,
I mean, but he is not at all is entitled to get the electricity because there is already electricity in my favor.
So how are you affected if he gets electricity?
He is a licensee holder.
Licensee of
and
that
he's trying to vacate me on the position. That's another part of aspect of law, but he's not entitled. So kindly,
he's a licensee of the same premises.
But I am challenging it because without my consent, I signed it because I'm a layman and I have no one.
Why should your consent be taken?
No.
You are also a licensee there.
There's no scope of licensing because it's Khas 1 land.
Whose Khas land?
Government of West Bengal.
Governments. You say you are paying. You are a riot there.
No, I'm not a riot. I'm a possessor. By which way legal or illegal.
Both persons have equal right. The petitioner contends that due to objection by the private respondent number 5, electricity connection cannot be given by the WBSCDCL to the petitioner at the property. Full stop. To show prima facie possession, the petitioner has annexed certain tax receipt and other documents to the writ petition. Full stop. Next para. Learned counsel for the private respondent number 5 controverts the allegations of the petitioner and submits that the petitioner is a mere licensee and has no locus standi or legal right to be in occupation of the property in question. Full stop. Next para. It is further submitted that the property is a khas property and belongs to the government, and the private respondent has been paying tax and receipts therefore are in custody of the private respondents. Full stop. Next para. The private respondent seeks some time to furnish such documents. Full stop. Next para. The learned counsel for the WBSCDCL submits that in principle the WBSCDCL does not have any objection to give electricity connection to the petitioner, but for the obstruction raised by the private respondents and a proceeding initiated by the private respondent under section 144 of the Code of Criminal Procedure. Full stop. Next para. Upon hearing learned counsel, it is evident that although the private respondent is disputing the legality of the possession of the petitioner, comma, the petitioner has furnished sufficient prima facie proof of occupation of the property, comma, irrespective of the legality of the same. Full stop. It is settled position of law that an occupier, comma, irrespective of the lawfulness of such occupation, comma, is entitled to get electricity connection under Section 43 of the Electricity Act 2003. Full stop. Inasmuch as the dispute between the petitioner and the private respondent regarding legality of their respective positions is concerned, comma, the same is not the subject matter of the writ court within the limited conspectus of the present matter, and it will be open to both the parties to urge such questions before any competent civil court or other forum if need be. Full stop. Next para. However, comma, in view of the above observations, the petitioner has a right to get electricity connection, which will, however, not confer any special right or equity in favor of the petitioner. Full stop. Accordingly, WPA 24614 of 2023 is allowed, thereby directing the WBSEDCL to give electricity connection to the petitioner at the earliest, comma, positively within a fortnight from the date of compliance of all formalities in that regard by the petitioner. Full stop. Next para. In the event any obstruction is raised by the private respondent number 5, it will be open to the WBSEDCL to approach respondent number 4, the inspector in charge of the Chonditola police station, for adequate police assistance in that regard. Full stop. The respondent number 4, comma, if necessary, comma, shall be entitled to remove any padlock for giving such connection to the petitioner. Full stop. Next para. However, comma, it is further clarified that nothing in this order shall create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have in law. Full stop. The costs for police help as directed above shall be paid by the petitioner. No address to cause urgency.
Your Lordship, one indulgence, just kindly observe them. I am changing the maintainability. If you, Your Lordship, deem fit.
Maintainability of the writ petition?
Yes, kindly observe it.
On what ground? His locus standi?
Yes, yes. It's a khas. Kindly observe it.
প্রথম সেন্টেন্সে করে দিন। At the outset, learned counsel for the respondent number 5 challenges the maintainability of the writ petition on the ground of locus standi of the petitioner, full stop. However, comma, in view of the discussions made herein below, comma, such point is not being entertained. Then the rest follows.
Oblige yours.
Yep. Yes.
I beg to appear for the respondent. I appear for the respondent number 3, the private respondent.
Right. What is the matter?
Yeah.
Please take the microphone a bit closer.
Yeah. Point involved in this matter, madam. Whether the mediation center can allow the advocate on behalf of the client.
MSME Council.
SOP. SOP. Standard operational procedure.
No, before which authority?
Authority method, district ad hoc, I mean district
legal service authority.
Legal service authority.
Not 24/1.
Not 24.
So what have you challenged? Any particular order?
No, they have passed the order. My advocate is gone there. Then he has not allowed to proceed and dispose of the matter without my allowed my.
Where is that order?
Yes, madam. Page 25, Milord, is a challenging an order, Milord, non-starter. A non-starter report has been issued as a 12A of Milord, the Commercial Courts Act is challenging that.
Because the opposite party, he did not appear.
He did not appear.
His advocate was there, he was not part.
He is not allowed to. He is not filed to give the Bhogaratnama.
No, there is questions of filing of Bhogaratnama.
No, there is no process of, in mediation, you have to appear yourself.
Yes. No.
Yes,
there is a point, Milord, I can show. Or council.
Show me that.
Yes, Milord.
But this is the standard operating SOPs.
I show you.
Advocate is not required at all.
Whatever may be. Mediation center can allow.
Bhogaratama is not necessary.
No, not necessary. Does it mean that if some advocate goes, he will not be allowed?
My lord,
let him show the photo. Yes.
Commercial Courts Pre-Institution Mediation.
Which act is this?
Commercial Act.
Commercial Courts Act.
Commercial Courts Act. 2015. Yes, my lord. I'll show you, lordship. May I have a handover?
Oh, it's a mediation under the Commercial Courts Act.
Yes, madam.
Which section?
12. Section 12A. Which is mandatory, madam.
Yes.
Come to the rules.
First, let us see the section.
Start.
All right, rules.
Rules, commercial courts, pre-institution mediation, settle rules 2018.
Which rule? Rule number?
Rule 7, rule 6, I remember.
Representation of parties.
A party to a commercial.
Yes, or council.
Or
You are
council.
right.
Yes, sir.
Mediation is not the court.
Hey, rules is there.
It is a mediation settlement center only. Mediation settlement center.
If it is under this act,
yes, my lord.
Under this
then you have to permit advocates also.
This one was created later. Only mediation as mediation
I
center.
can understand why I don't understand.
Which provision of the SOP are you relying on?
Yes.
Which provision of the SOP?
Yes.
Where is the bar in the SOP to
Yes.
advocate appearing?
No, there is two part. Whenever complaint, application made before the SOP for compromise. Then SOP.
SOP is standard operating procedure.
Yeah,
There cannot be any appearance before SOP.
It is
What are you saying?
only mediation settlement center. This is the question of contesting. He was to contest the matter.
No, in mediation, representation of parties rules allow. He can be
Both party
represented.
can-
Even if it's for conciliation, then the advocate can be there.
Both party can be. This center only
Permit
for-
him, I'll dispose of the writ petition by directing you to reconsider upon permitting his counsel to. You are for the?
I am the private respondent, my lord. On
Acha, yes.
my lord, first of all, my lord, this writ petition is not maintainable. Kindly, my lord, see the cost title. It has been filed by the sole proprietor in its own name. The first point, my lord, it has been filed by Krishna Traders.
Krishna Traders represented by proprietor Shubhankar Mohan Shah.
In the name of the proprietor, my lord.
Technically.
Second, my lord, he has suppressed one fact is that challenging the same self-order. He has filed a 227, my lord, where, my lord, there
No.
was a
This. Oh, sorry.
my lord,
Sorry.
where there was a direction, my lord, to serve a copy upon me. That he has suppressed in the writ petition that the same order of non-starter has been challenged in a 227, my lord. This, if he can disclose this petition, it will appear, my lord. This is, my lord, what transfer from the learned court, honorable court, my lord, while this petition was taken up. He did not appear on that.
Yes.
No, my lord. This is another point.
What was challenged here?
I challenge here the mediation. Look at standard of the mediation. That my landed for client, 2 steps of mediation. MSMK, and here also. Opinion and difference arises. So for that purpose, he cannot challenge. I have
You got a
challenged.
copy of that 227.
They have not served. Milord, there are 2 CO. One, Milord, he says that in mediator, Milord, there has to be a council committee. That is pending. I have been served.
I'll record everything. Just bring a copy of the 227 to day after tomorrow. I'll keep it as at the top of the list. Learned counsel for the petitioner contends that
And Milord, one more.
when the petitioner sought to be represented through counsel before the mediation center in a mediation proceeding under the Commercial Courts Act 2015, the Office of the District Legal Services Authority gave a non-starter report on the ground that there was non-appearance of the opposite party. Full stop. However, the present petitioner who was the opposite party therein, was very much represented through counsel who was not permitted to appear before the said forum. Full stop. Next para. Learned counsel cites Rule 6 of the Commercial Courts within bracket pre-institution mediation and settlement bracket closed rules, 2018, which stipulates that a party to a commercial dispute shall appear before the authority or mediator as the case may be, either personally or through his duly authorized representative or counsel. Push up next para. Learned counsel appearing for the respondent number 3 submits that another application under Article 227 of the Constitution of India bearing CO 2811 of 2023 has been filed on the self-same cause of action by the petitioner, in which by an order dated October 9, 2023, a coordinate bench directed the matter to be listed subsequently. Full stop. However, comma, no copy of the same has been given to the to the respondent number 3 as yet. Full stop. Next para. Learned counsel appearing for the respondent authority submits that the proceeding is governed by the concerned standard operating procedure for pre-institution mediation and settlement. Full stop. Next para. Since a preliminary objection of multiple similar applications having been filed has been taken by respondent number 3, comma, learned counsel for the petitioner shall produce a copy of the application under Article 227 of the Constitution, which was numbered as CO 2811 of 2023 on the next date of hearing for proper and effective adjudication of the present petition. Full stop. Accordingly, the matter shall be listed at the top of the list on November 22, 2023 for passing further orders.
Make it Friday.
Friday, very well.
Friday, I have some problem, my lord. Difficulty.
Give me another
Monday,
date.
Monday, my
lord. Monday, I have some problem because there is a holiday.
Monday is holiday.
Very well. Next returnable date is November 28th, 2023.
November 28.
Thank you. I'll keep a copy of the standard operating procedure on record.
Yes. But mediation already closed, my lord.
No, not closed. It has been closed at the inception, non-starter. It has been said.
The rule is that they will have to appear and then first
Further
indicate whether they
reopen the
want to
case.
go for mediation or not.
Further
It has been said it's a non-starter.
Yes, my lord.
If his advocate was there, the advocate was not permitted. If the advocate had said that yes, we are willing,
This is not the
Even in
truth.
writing, my lord.
he was not. He was precluded. That is
Only
his allegation.
allegation, they are accepting the vocal now, my lord.
Yes, my lord. There is no correspondence to the
Only
authority that
allegation
my
against the
advocate
vocal
was
now.
not permitted even. They will have to give it in writing that I am interested in the mediation. There is no letter to the writ petition indicating
yes.
that my advocate was present there and he wanted to file a vakalatnama, which he was
Maybe
not.
later was taken by the advocate, but you did not permit.
No reflection.
How do you know that?
They could have sent then by
No,
post
no.
also.
This
There
is
is no
not
letter on
This
it.
is not
Not done that. They've come up
This
with
is not
challenge.
true.
If you did not permit him, after that you cannot.
No, no. He appear, my lord.
Then why did you file this writ petition? Unnecessary.
Only
costs.
delay, my lord. Only drag the matter. Only delay.
He has filed two proceedings.
Only delay, my
Well,
lord.
bring your 227 application on the next day.
Why 227 another?
Either way, I shall decide the application. He'll have to take his call. Whichever way. If he wants mediation, then he has to do it.
Yes.
Otherwise, he'll go.
There are dues to the extent of 82 lakhs. That's he was.
It will be decided on 28th, whenever it is necessary.
Under the mediation note.
But Article 227 another jurisdiction. my lord. I challenge the authority of the mediation center. There.
We'll look into that.
Hey, my lord.
It will be better for you if I decide in this. Because otherwise, that 227 will never be heard. Yes, next.
28.
23.
Yes, 23.
I am appearing for 4 and 5, my lord.
4 and 5, right? Yes.
My lord, I beg to appear for private respondent number 6 in this matter.
6.
I appear for the petitioner.
Who are for 1 and 2?
There are, this is,
You have served on 1 and 2?
Lordship, I have served. Lordship, this is my affidavit of service.
Yes, what happened?
Lordship, this is, Lordship, the private respondents are Bangladeshi nationals.
Right.
Lordship, suppressing that also, that, Lordship, they have obtained voter card and Aadhaar card. I have written to the authorities stating that they
How are
have.
they related to you?
They
Your
are related to me.
Husband and mother-in-law?
Lordship, they are my brothers in law. One is the nephew, there is the son of my brother-in-law, and the
Son of your brother-in-law means?
Lordship, Bijoy
Brother-in-law
Kumar,
means?
respondent number 6 is the brother-in-law. Respondent number 7 is
Brother-in-law
his
means
son,
brother of whom?
brother of my husband. Lordship, my brother, my husband is a UK national. His brothers are Bangladeshi nationals. I am an Indian citizen. Lordship, my husband gave money to his brothers for purchasing a property. Lordship, they are Bangladeshi nationals. They won't be able to purchase it. So they said that it should be purchased in my name. But Lordship, they forged these documents, Aadhaar card and voter cards.
Your husband's documents?
Their documents. They suppressed that they are Bangladeshi nationals. They made themselves to seem like they are Indian
Oh, they
citizens.
faked Aadhaar card and all this?
Not, they did not fake. They obtained it. Lordship, it is so easy to obtain an Aadhaar card and voter card.
Yes.
They very easily obtained an Aadhaar card, voter card, and they used it. They purchased it in their names. Lordship, now my contention is the authority should decide that a Bangladeshi national cannot, Lordship, obtain an Aadhaar
Your
card. And
relationship with your husband is estranged now.
no, it's not estranged.
Then what prompted you suddenly to do this?
Lordship, because they.
How are you affected?
They have, Lordship, because they have.
As a good citizen.
No, my lord. They have.
What is your
forged
locus
the
standi?
documents.
What is your locus standi?
My locus standi is I should have been the owner of that property. Whereas now they are also a owner of the property.
You say
Along
they
with
have
me.
purchased property.
They've purchased properties. In the what with my husband's money, they purchased property.
Your husband gave the money to them.
Lordship.
So
No,
how
not
are
as
you
a gift. Not as a gift. Lordship, that lordship was part of a suit which is in Alipur court. That is pending.
Your husband gave money to them.
To his brothers.
To his brothers. So how do
Saying
you
that
come in the
please
picture?
purchase this property and do the needful. Lordship, we are very established businessmen. We have got business
Yes.
throughout India, Bangladesh, and England. Lordship, we gave this money to the brothers-in-law, who, Lordship, when they got the money, Lordship, instead of
Your husband gave. What is your locus standi here? I don't understand.
Lordship, I am the owner. I'm also the owner. I'm also the owner of that property.
From your husband's money.
Lordship.
Husband gave money to them and to you. You are co-purchasers. Or what?
We are now shown to be co-purchasers. But it ought to have been, the entirety ought to have been in my name.
So you made complaints.
Lordship.
What is your present cause of action? What happened then?
The complaint is not non-consideration of the complaint that they are Bangladeshi
Yes, you
citizens.
deny whatever they're saying. Let them
My lord,
consider it.
may I have the leave? Because my lord, I have not filed my wakalatnama. I will file it on the next date if my lord calls for affidavit, my lord. My lord will kindly see the basis on which they are making this claim. My lord, the documents that they are relying on appears from page 14, annex to this writ petition, my lord. My lord, the first document is the TIN number, Government of the People's Republic of Bangladesh, National Board of Revenue. My lord kindly turns over the page 15. My lord, Gono Projatantri Bangladesh Sarkar. This is the identity card of Giridhari Lal Modi. Then comes the.
We'll come back in 10 minutes and continue.
My lord.
Yes, please.
My lord. My lord, as I was indicating from page 14
Right.
of
See, they have made certain allegations against
My
you.
lord.
Let that be decided, but let that be investigated into by them.
My lord, only whether the
That is my innocuous prayer.
the petition is maintainable because my lord, as
Not
I've
against
already
you may be
demonstrated these
right,
documents, my lord,
but they are
these
the authorities. Yes.
my lord, these are authorities issued by authorities, but my lord, they have not been apostolized, my lord.
Not been
Apostolized under the Hague Convention, my lord. Now, I bow down before my lord that perhaps Bangladesh was not a signatory to that treaty, but then still it should have been issued by either their our counterpart of their
Let that
Ministry
be
of
decided
External
by the
Affairs.
authorities. Take that point before the authorities. I'll direct them to give a hearing to you also, definitely.
My lord,
Direct them to do that.
my lord,
Yes,
as on,
Mr. Samant.
But as on date, I have got no instruction because this has been served in the vacation time, my lord. But presently, there has been also.
Enter into the merits of the matter, which we cannot. So I'll
My lord,
just
then page 40, P4 or P5, my lord. That is the
Last representation was 9th October 2023, page 54. There are three, Lordship, may I indicate, there are three lines of complaint. One is to the Aadhaar authorities. Second is to the electoral officers for the voter cards, Aadhaar authorities for the Aadhaar cards, and to the officer in charge for they must have forged
all
documents.
of them are parties here.
They're
I'll
all
direct the
parties.
respondents to consider these.
Lordship. But Lordship, kindly indicate the three lines of the three lines of complaint. One is Aadhaar, voter card, and the forgery of documents which
My
they
lord,
had.
with regard to the voter card, my lord, respondent of 5 is the authority, my lord. Electoral registers officer. If you lordship kindly direct, my lord, it is respondent of 5, my lord. Electoral registers officer for this voter ID card, my lord.
I is the only electoral registration
Yes, my
officer.
lord. Because
What about the other authorities?
The other is Lordship, the respondent number
2, my lord.
2.
2 is the
My
authority.
lord, only thing, if my lord is inclined today to allow the writ petition by directing the respondent authorities to consider it, then my lord, may I be kindly permitted to use an affidavit, my lord, in that?
No, not here. I'll direct that you will be heard also by them.
Lordship.
The grievance of the petitioner is that the private respondents are Bangladeshi citizens. Full stop, next para. It transpires that there are certain disputes pertaining to property also between the petitioner and the private respondents who are in-laws between themselves. Full stop, be that as it may, comma, it is beyond the scope of the writ petition to adjudicate on merits the allegations made with regard to the private respondents having obtained documents of Indian citizenship fraudulently, comma, including Aadhaar card and voter's identity card, and likewise. Full stop, next para. Learned counsel for the private respondents controverts the allegations made by the petitioner and submits that the present writ petition is not maintainable. Full stop, next para. Be that as it may, comma, the limited scope of the writ petition is that the petitioner has made complaints against the private respondents on the premise that the private respondents are Bangladeshi citizens, comma, seeking cancellation of their Aadhaar cards, comma, voter identity cards, and other documents. Full stop, next para. Hence, WPA 25295 of 2023 is disposed of by directing the respondent authorities, comma, in particular the respondent number 2 and the respondent number 5 to decide on the representation given by the petitioner annexed at page 54 of the writ petition and to take appropriate steps accordingly, comma, by undertaking an inquiry, comma, if the respondents so deem fit in that regard. Full stop. If such an inquiry is undertaken, comma, the respondents authorities shall give an opportunity of representation and hearing to the private respondents against whom the said allegations have been made. Full stop. It is made clear that the merits of the allegations made in the writ petition have not been gone into, and, comma, as affidavits have not been invited, comma, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. No address to cause.
My lord, I have one prayer, my lord. My lord, kindly make it clear, my lord.
So his allegation is against all private respondents. You may be against 6.
Very well, my lord.
My lord, kindly make it clear with respondent 2, my lord, with regard to the voter ID card, my lord. Kindly make it clear, my lord.
Whatever. Yes.
My lord, kindly, my lord, that part, because 2 and 5, my lord, with regard to 5, my lord, only it is the voter card, my
Lordship,
lord.
kindly takes page 54. There is a Aadhaar authority situated in Kolkata also, Lordship. May I add him a party, Lordship?
Not now. Yes, next matter.
Much obliged.
24.
Yes.
My lord, I appear for the petitioner, my lord.
Yes, Mr. Dattu, what is the matter?
My lord, challenging an order of the, my lord, identification committee and review committee. But my lord, service, my lord, I had served my affidavit of service, my lord, it's not yet, my lord, punched, but they had received hand service on 18th of October. My lord, since it is coming after some time, if lordship wants that I
Give
serve them
another
again,
notice, I'll take up on.
only prayer, my lord, if it may retain its position, my lord, as it is, my lord. Any day convenient to the bench, my lord. And
Yes.
the ground on which I, my lord, seek to challenge is that the evidence that was, my lord, relied upon against the borrower, that, my lord, despite request was not, my lord, I am covered by, my lord, authority. That's the, my lord, principal ground on which I seek to challenge.
Despite service, none appears for the respondents. Full let a notice be served on the respondents indicating that the matter shall be listed under the heading upgraded matters on November 24, 2023. A receipt in that regard shall be filed on the next returnable date by the petitioner.
My lord, I am
Affidavit of
seeking this
service-
liberty, my lord, to file it in 1 hour's time, my lord. Just it's getting
liberty is granted to the petitioner to file affidavit of service during the course of the day.
grateful, my lord. Getting in the file code.
25.
Item 25, my lord. The service has not yet been effected, lordship. May I just prefer 1 week accommodation.
When did you send?
But I have sent on Saturday itself, my lord.
Service has not yet been completed. Let the matter stand adjourned and shall next be listed in the monthly list of December 2023.
Lordship, month list, my lord. May I prefer 1
Monthly
week?
list of December, nothing else. Yes, next.
26.
I am for the petitioner, my lord.
My lord, I am for the respondent number 1 to 4.
Total, all service is not affected till date.
Service is not yet complete. As per learned counsel for the petitioner, let the matter be listed in the monthly list of December.
My lord, may I submit that they have incomplete. My lord,
Please give complete copies. Please check up.
next.
Resolve this between yourselves, right? Complain to the court.
I've served already. I have the evidence.
Give another copy of the annexure.
Yes, yes,
yes.
27.
Yes.
27.
27.
Respond number 1 and 2.
You're for the
Respond
respondent. 1 and 2.
On prayer for not today.
No, move the matter.
I'm a senior
Who is your senior?
advocate, Ganesh Chandra Patra.
No, move the matter. What is the matter about?
I don't know. Due to his illness, he was not come.
On the prayer of the petitioner, the matter is adjourned and shall next be listed in the monthly list of December. Please come back.
Worship, in course of the day, I will be filing a vakalat now.
Nothing is legal to
I'll do that.
do that, but do
I'll
that
do
because your
that.
name is being recorded.
No, I'll do that. My advocate record.
আচ্ছা একটা লাইন অ্যাড করে দাও leave is granted to learned counsel the learned advocate for the respondent numbers 1 and 2 to file his wakalat number during the course of the day.
Grateful, Lord.
Thank
28.
When appearing under the petitioner,
Yes.
I served the copy to the respondent number 2 and 3, but the returned with a note that they have left. But I have come to know now they have shifted to another place. So may leave may be granted maybe to add the address in the cost title.
Very good. On the prayer of learned counsel for the petitioner, leave is granted to the learned advocate on record for the petitioner to correct the cause title of the writ petition by incorporating the current address of the respondent numbers
2 and 3.
2 and 3. 2 and 3.
Yes.
Full stop. Further affidavit, you are filing an affidavit of service today?
Today I can file the
No, file a composite affidavit.
because the 2 and 3 is unserved. So
Right.
it will be not
Thereafter,
proper.
service shall be effected on all the respondents and a proper affidavit of service shall be filed on the next returnable date. Full stop. The matter shall be listed in the monthly list of December.
My lord, cannot be. Next week, it will be within Calcutta. Both the respondents
Very
will be
well.
in Calcutta.
The matter shall next be listed on November 28, 2023.
Shall I incorporate the address there in the cost title?
Yes, I've given you leave. Do it
Leave it.
during the course of the day.
Address that cost.
The usual thing. I mean it with the leave of court.
29.
My 29, I am for CSC, Lord.
Yes.
Man, the final order of assessment passed in 2021. And
Mr. Haldar? No, somebody else.
it was passed on 26 July 2021.
What is the ground taken, Dr.
But
Shah?
they said that they have been given opportunity of hearing. If your lordship kindly come to page 22, final order of assessment. Kindly come to page 23 for a moment, lordship.
Yes.
I have got the document, but I'm as advised, Rahul Bose, authorized representative of the subject matter consumer such and such, appeared before me on the rescheduled date on sir. In the first date, failed to appear. Subsequently, notice has been served. Thereafter, their representative appeared, lordship. And I have got the documents regarding that aspect that they have appeared there.
None appears at the time of call for the petitioner, although the WBSCTC,
CSC,
although the CSC Limited is represented through counsel. Full stop. Learned counsel for the CSC Limited rightly points out that
My lord, I am what a petitioner.
No.
But my lord, the advocate in court was hurting injured, my lord. He has been hospitalized.
You have also been hospitalized. Why are you speaking like that?
Stay, take breath, take breath.
What happened to him?
I'm coming
Today?
just
Oh, is it serious or is it something?
no.
When should I take it up? Tell me.
My lord, tomorrow, my lord.
Tomorrow?
Tomorrow is a holiday.
Day after,
Well, on the prayer of the on the prayer
day
of the
after tomorrow, my lord. Day after tomorrow. Wednesday, my lord.
on the prayer of the petitioner, let the matter stand adjourned for the day. Day after tomorrow.
My lord,
30.
Yes.
My lord, I am appearing for respondent number 4.
Respondent.
Lord, say, for the respondent number 1, 2, and 3.
Although the respondents are represented, none appears for the petitioner, who serves as a last chance to the petitioner to move the matter. The same is adjourned for the day.
Thirty-one.
Lordship, in this matter, I am appearing on behalf of the petitioner. Lordship, service upon the state respondent is not completed yet.
Why not?
Lordship, I sent my clerk to serve on Saturday, but that time
Service is not yet complete. Full stop. Let the matter stand adjourned for the day.
Oblige, your lordship.
Thirty-two.
Lordship, in this matter, I'm appearing on behalf. Yes, no. I'm appearing in this matter on behalf of the petitioner.
Yes.
Lordship.
Where is the service?
Service has been completed, but affidavit service has not been prepared.
Prepare an affidavit of
Lordship,
service.
I am just withdrawing this matter as the relief has been paid in this petition has been complied by the authority. Respondent number
Learned
2.
counsel for the petitioner submits that the writ petition has become infructuous in view of the relief sought herein having already been granted. Full stop. Accordingly, WPA 25514 of 2023 is dismissed for non-prosecution without any order as to cost.
Oblige, your lordship.
Thirty-three.
33, I beg to appear on behalf of the petitioner, my lord. The service is not affected, my lord.
Service not affected. Next monthly list.
28, my lord.
Next month.
Deeply list.
Thirty-four.
None appears for the parties. Adjourned for the day.
Thirty-five.
Your Lordship, I am appearing for the petition on this matter.
Yes.
This is my
The
affidavit.
respondents 5 to 7.
It's a affidavit of service. So, Lordship, I'm praying for an adjournment on the ground of my learned senior. I've been led by Mr. Kollol Bashu in this matter. He's on legs before a different bench. Just not today, Your Lordship. He will address Your Lordship on the next day. My affidavit service is there, man.
With regards to the matter, my lord, a similar matter was heard by my lord on Saturday. Then an order was passed whereby my lord had directed me to file an affidavit with regards to the technical committee of the bank, my lord. This was with regards to a valuer caution list. Yes, my lord. Now, where I had mentioned that we have a technical team in place, but I did not know the composition of the team for
Oh.
which I had sought for direction for affidavits.
I'll make it not today. Please take instruction. Come prepared on the next.
You know, with regards to the aspect of the technical committee that I have indicated to my clients, on Saturday this order was passed.
Yes.
They are supposed to come today with their feedback on whatever the comments.
This matter I'll adjourn for the day. You take instructions on this matter also. I'm not directing.
Not keep it on very minute. On 22nd, I will not be able to prepare an affidavit by then, minute.
Your Lordship, we will press for an interim order, then whatever falls from Your Lordship.
No. I'll keep it on 23rd November then.
Very good.
Deeply obliged, Your Lordship.
An adjournment is sought by the petitioners. Let the matter stand adjourned till November 23, 2023.
Very good. Deeply obliged.
Ms. Shah, please keep this with you.
Yes, I have copies of this.
Ajay.
Yes,
Your Lordship, the affidavit of service.
Affidavit of service file today be kept on.
Deeply obliged, Your Lordship.
36.
36, it's kind of a new matter, Your Lordship. I'm for the petition.
Kind of a new matter means?
It's relating to the exotic species, the macaw birds. Now, Your Lordship, I'm led by Mr. Senthil Kumar. He's from Madras High Court. So the technical thing, my lord, the affidavit of service, my lord, I'm just placing it on record. Otherwise, the entire matter, my lord, he'll be arguing.
Very well. No difference.
Your Lordship, I'm appearing for the state. Your Lordship, I'm praying for a short adjournment.
Why?
Your Lordship, I'm led by Mr. Rajoshri Bashu. He is not present today. And in the meantime, I will get the report from the department as well.
State as a respondent.
What is the dispute involved here?
Yes.
Please open the dispute. Yes.
Yes.
Please take the microphone. Yes.
This is a matter relating to the exotic live species that
Right.
is non-native of Indian origin. Whereas the Union Government of India, being the first respondent here, they have introduced an advisory scheme. In that advisory scheme on 2020, they have announced all the breeders and traders, those who are in possession of the exotic live species, to make a voluntary disclosure with an immunity, with a clear immunity that those persons, those who are declared in the voluntary disclosure scheme under a Parivesh website portal belongs to the Union Government. So we will be free from legally any criminal prosecutions. Based on which all the persons in India, including the petitioner, has submitted their proposals in the Parivesh ID. But what subsequently happened is that a new amendment has been introduced by the Union Government, that is Wildlife Protection Amendment Act 2022. In that also, the same thing has been stated in section 49M that I have to disclose all my exotic live species in the Parivesh portal. But whereas the Parivesh rules, what it says clearly.
Deal with these birds species.
All exotic kind of species, including mammals, birds, animals, reptiles, whatever it may be.
Everything. Yes.
So what the petitioner here before this court is that he has rightly submitted all his proposals in the Parivesh ID right from 2020. From the date of introduction, he has rightly introduced. In the Parivesh proposal, there is one option called as the voluntary disclosure comes from 2020 to 2021. That is 1 year time span has been happened. After that, the registered birds, more particularly in this case, birds are involved. So the birds, those who have already registered in Parivesh, if they gave birth for some other progenies in future, that has to be included in the Parivesh ID voluntarily by the petitioner. So he has rightly done that. Then subsequently, if there is any transfer or change of possession, whatever, or death, whatever it happens, it has to be included in the Parivesh. So that was also rightly done by the party. But here the question is that it is an immunity granted and an amnesty scheme. So now the Chief Wildlife Warden of West Bengal, he has rejected all the proposals without having any consideration about the back papers. For example, I will tell you one small example. One macaw parent bird was declared in 2020. It was literally verified physically according to the Parivesh rules. They came to my house, they have verified physically, and they have given a certificate of ownership with seal and signature.
Right.
But subsequently, they have rejected the same paper without considering the earlier thing. If I am submitting my death, it's a voluntary scheme. So if I want to take my immunity, so I have to submit myself. So after submitting that, my bird was dead. That was also rejected. A lot of papers has been rejected without considering any aspects of the rules.
Where is the rejection, please?
I will show you. It is already in the petition for your lordship's.
No, in the petition, just give me the page number.
Yes, page number 29 to 36. On humble submission, my lord, I have made it separate synopsis for that. I may permit to serve this. It will be easy.
Hand over a copy of the synopsis and give a copy to them also. Then.
It's for your lordship's convenience to take, because there are some small numbers Xerox is there.
But give a copy to them
Yes,
also.
yes. I will serve.
No, this is a list of the bird.
Yes.
But I want to see the rejection itself. The rejection order.
That is in page number. I invite your lordship to take page number 29 to 36. Page number 29 to 36.
49 to 36.
29. 29. In page number 29, your lordship can see it is a declaration of stock.
Right.
That is annexure 5. The declaration of stock. In the bottom, your lordship can see the status. The proposal is approved.
Yes.
Yes. Over the page, the second page, there is a seal and signature of the chief wildlife warden.
Right.
Who was given the ownership certificate also. But subsequently, one second. Page number 36.
Right. Rejection.
Yes, rejected. The back papers, what I have shown earlier, is the declaration done in 2020. So from that 2020, it has been literally approved. But subsequently, without considering their own ownership certificate, now they have rejected. My legal question before this court is that whether the Parvesh Rules 2020, which is called as the amnesty scheme, it is the only act and rule which gives power to the chief wildlife warden, and it has to act in accordance with that Parvesh Rules. But whereas the Parvesh Rules itself did not give any right for rejection. So that is the worst part of the case here. So if anything, the chief
direct affidavits to them instead of giving them.
So
because there is no scope of interim order that will grant them in relief. So how soon can you file your affidavit? I'll give you 2 weeks to file your affidavit. Just disclose everything. All your reasons and all whatever, so that they can give a reply. I'll direct them 2 weeks to file an opposition.
Any short date means it will be helpful for me.
Before 2 days, nothing moves.
Okay.
Your Lordship, I would just intervene here. They have not made a party formally to the state. Let the state be made a party.
It is a scheme and the law introduced by the Union Government of India.
Union Government of India is
the Chief Wildlife Warden is a statutory authority, but the state
who has refused? The Principal Chief Wildlife Warden.
Yes, my lord.
He has been made a party. I'll direct them to file. State is not necessarily a party. State of West Bengal has not refused it as such. I mean, this is the act of the Principal Chief Wildlife Warden. So he has to answer for it. The grievance of the petitioner is that under the Parivesh rules, approvals were being given to the petitioner with regard to exotic live species. However, by the impugned decision, the respondent number 2, that is the Principal Chief Wildlife Warden, without assigning any reason and dehorsed the rules, have rejected such proposal of the petitioner. Next para, since an arguable question has been raised, the respondents are directed to file their affidavits in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed under the heading upgraded matters on December 12, 2023. Immediately after that period, 12th December, this will appear under the upgraded heading. Please come. Thank you. A copy of the synopsis handed over in court today be kept on record.
May I just please, Lordship, with this leave of this court, may I submit one
As
thing?
a affidavit of service kept on record.
Yes, your Lordship.
That
Thank you.
37.
37, Your Lordship, I am for the petitioner.
Yes.
Your Lordship, kindly takes up the cost title, Your Lordship. The respondent number 1, Union of India. I have mentioned the address as 11 Stranded Road, Kolkata, Your Lordship. Now they are not accepting it. They are saying you have to give the address of Delhi. If your lordship kindly grants me leave to correct that address, your lordship.
Do
And
that
keeps it next week.
yes. Learned counsel for the petitioner seeks leave to amend the cause title of the writ petition inasmuch as the address of the respondent number 1 is concerned. For such leave is granted to the learned advocate on record for the petitioner to carry out the necessary amendment to the cause title during the course of the day. An amended copy of the writ petition shall be served on the respondents or only
Respondent 1.
the others have been served
Actually, generally,
on the respondents. The petitioner shall file an affidavit of service on the next returnable date. In 1 week, you cannot. I'll give you 2 weeks.
my lord.
The matter shall next be listed on December 5, 2023.
Right.
Thank you.
Lord, I am for the petitioner, may I humbly seek accommodation. The counsel is not here.
Not today then.
Although are covered by your lordship's order, but since my learned friend is here.
Lord, this accommodation will help me, Lord. I am for the Union of India, only respond number 1. I have also received this brief today, Lord. So
I'll take it up day after tomorrow. Tomorrow is a holiday. I'll take it up. On the prayer of learned counsel, the matter is adjourned for the day.
Much obliged. Also, next matter, my lord, similar.
Let it be called on.
39.
39, same order. You are appearing there also?
No, Lord. Only in 1 month.
On the prayer of 39, on the prayer of learned counsel for the petitioner. The matter is adjourned for the day.
Much obliged.
40.
Lord, I am for the respondent. 40, my lord, I am behalf of the petitioner, my lord. My lord, praying short pass over.
No, refuse. Move the order.
My lord, Learned Admiral Mr. Joydeep Banerjee is come. My lord,
let him come. In the meantime, move the order.
My lord, I have no brief.
What is the matter about?
My lord, may I please your lordship?
Yes, yes.
My lord, he is seeking, basically, my lord, my learned friend is seeking a stay, my lord, on the DM order which has been passed under section 14 of the SARFAESI Act, on the ground that, my lord, the DRT2 is unavailable, my lord. My lord, I am objecting to that stay, my lord. As and when, my lord, he pleases, my lord, I'll.
No, then come back tomorrow. An adjournment is sought by the petitioner, although the respondent bank is represented through counsel. Let the matter stand adjourned for the day.
I'm so grateful. Grateful.
Thank you.
41.
41, my lord, I am for the petitioners. My lord, this is the affidavit of service.
Right.
In fact, my lord, what happened, my lord, in this matter, kindly come to para 46, the short grievance of the petitioners.
No, appearing in person.
In person?
As a secretary of the application. And different parts of the paragraphs, application has been made that I have done fraud. That I have to decide, that I have to give the reply.
Let him file affidavit.
So what is the grievance about?
My lord, kindly come to para 46.
Page or para?
Para 46, page 19. No AGM for the last 3-4 years. Even the AGM held in 22, they are saying that there is no quorum. And the last, according to them, the last AGM held at para 8 in 2019. How this secretary is calling that I fail to understand, whatever it may be.
Anyway, I have been given the
Yes.
I have done fraud. All the fraud be
You are which respondent?
Is respondent number 5.
The fraud be
Yes.
Yes.
I'm appearing for the society concern.
You have also committed fraud?
No, cannot be.
Two, your lordship, there are disputed facts, your lordship, in this writ petition, your lordship, that has to be dealt by an
Yes.
Since
in the meantime,
since disputed questions, including allegations of fraud, have been leveled in the writ petition, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Within 4 weeks from date. Reply, if any, shall be filed on the next returnable date. The matter shall be listed on January 8, 2023 for hearing.
In the meantime, my lord, what happened? After filing of this writ, we have received the notice issued by Secretary, my lord, that AGM, the AGM is likely to be held on 26th November. What will be the effect? What will be the effect of this AGM?
72, page 72, my lord.
Anyway.
They have given a letter And the persons who have signed this, that none of them signed in the letter itself. They have signed in the different sheets. I will bring the affidavit of them also. They have not signed it to the
Yes. Any action, Artel and Atco, any action taken in the meantime by the respondent association shall abide by the outcome of the
Yes.
Grateful, my lord.
This is for the state.
Yeah. Affidavit of service may be kept.
Service be kept.
42.
What about service?
Not ready, my lord.
Service is not ready. Why?
Already short, but only except 5 and 6 the private respondent. Not yet been returned the private standing the factory.
You are for?
If I appear for the respondent number 2, your lordship, online copies have been served earlier Friday evening.
So when should I keep it? Tell me your services are
Next week already short, but again.
very well. On the prayer of land counsel for the petitioner, since service has not yet been completed, let the matter stand adjourned till November 28, 2023. Pardon?
20 is some difficult.
29th?
29.
28th na go 29th kore. 43.
Lordship, I am appearing for the. May I hand over the affidavit of service, Lordship? Lordship, in this matter, Mr. Oyon Dotto is leading me, or he's on his legs.
Then let his leader come. If it is not maintainable, let his leader come. Otherwise, he'll be embarrassed. Why not maintainable? Say that because
civil suit pending, money pending, and also the order. And we have a look at the last page. Page 84, last page. That is the order asked by the gate recovery and the recovery officer.
Yes.
My lord, against that order, my lord, that will lie. Under section 30 of the.
Yes. You have challenged this.
No, Lordship, what has happened, Lordship? There are a series of litigation, Lordship. Now, this order has been passed officially, Lordship. If Lordship can see, the date has been manipulated also.
Go to the DRAT.
No, Lordship, the sale order has been given hurriedly, Lordship, without hearing us, Lordship. This is the difficulty, Lordship.
Go, this point can be taken before the appellate forum also. How is it maintainable here?
Your Lordship,
go before the DRAT.
I completely appreciate your Lordship. The only difficulty is that the property will be sold out. If that urgency was not there, your Lordship, we would not have come before your Lordship, because
you can take the same point before the DRAT also. Why didn't you go in the first?
I completely appreciate what has followed.
This is a very
Your
bad
Lordship
practice.
kindly gives us a protection for a time, for a limited time. We will go before the DRAT. Because what is happening essentially is this: the bank was a tenant.
Right.
They were supposed to give me rents.
So what prevented you from taking out an appeal instead of filing the writ petition?
Absolutely, I completely appreciate. I
could have done that today. You'd have been moving the stay application before the DRAT. Then it's your fault.
I completely appreciate. Your Lordship kindly gives a limited protection for
no protection. Sorry, no.
Because they are trying to sell out the property
even
and not paying instead of paying the rent, because there was already a compromise agreement.
No, this is a very convenient mode. You come before the writ court wrongly and you say that no, I'll go before there. Give me a short protection which will be extended by the DRAT. Why? You could have gone before the DRAT in the first place.
I completely appreciate. Your Lordship kindly makes the observation thereafter that it will be freshly adjudicated and heard out by the DRAT. I have no. Your Lordship kindly does not.
No.
Because then the whole property will be sold out and I won't be able to recover the rent even.
No. Learned counsel for the respondents.
There is a suit pending and nothing is being.
Learned counsel for the respondents at the outset takes an objection as to maintainability of the writ petition. So it is submitted that since an appeal is maintainable before the Debts Recovery Appellate Tribunal, the writ petition ought not to be entertained. Learned counsel for the petitioners pleads extreme urgency and submits that the petitioners are agreeable to go before the DRAT, but in the meantime, due to the palpable illegality committed, an interim protection be given. Next para. Such allegation of palpable illegality comma, of course, comma is disputed by the respondents. Full stop. Be that as it may, comma, the petitioners have an available and functioning forum by way of the DRAT against the order of the DRT which has been impugned herein. Full stop. Next para. There is no reason for this court interfering, comma, since if writ petitions are started to be entertained against orders of the DRT despite availability of equally efficacious alternative remedy, comma, a floodgate will unnecessarily be open, full stop. It is well settled that in such circumstances, comma, the court exercises a self-imposed restriction and relegates the matter to the appropriate forum to be exhausted. Full stop. Accordingly, WPA 25648 of 2023 is dismissed as not entertained, with liberty to the petitioners to approach the appropriate appellate forum with the self-same challenge as preferred in the present writ petition. Full stop. This court has not entered into the merits of the matter at all. Since no affidavits have been directed, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. No address to cause
Your Lordship, the difficulty was they only submitted before the DRT that the DRT does not have jurisdiction. Now, if I go before the DRT and now the DRT says, no, I have no jurisdiction, because then I am remediless.
You are challenging an order of the DRT.
Absolutely.
They have taken a point that DRT does not have
jurisdiction.
Even that point can be taken before the
Absolutely,
DRT.
Your Lordship. But now, if the DRT comes to a conclusion that
We
the
cannot
DRT
go
does
on
not.
conjecture and
Your Lord.
If DRT does not have jurisdiction, you win the appeal on that.
And in that case, Your Lordship kindly condones the time taken in filing.
Can I?
(44).
Yes.
My lord, I'm for the petition.
What about service?
Lordship, I've served upon the government plea.
Affidavit of service is required.
Not
Prepare, come back a day after tomorrow.
Lordship, great.
Since the affidavit of service is not ready, let the matter stand adjourned for the day.
Great.
Please come.
Lordship.
(45).
My lord.
Yes.
This is my application, my lord. My lord, here, my lord.
Private, right.
My lord, I, my lord, have challenged before, my lord, an order passed by the Real Estate Regulatory Authority, my lord, directing my client, my lord, who's admittedly a promoter in respect of a certain property, my lord, to, my lord, refund a certain amount that is being paid by the private respondent complainant to that has been paid to me, and to also impose penalty upon my client, my lord. My lord, my two grounds for coming before, my lord, and not availing the appellate remedy, my lord, which admittedly is available under I will satisfy, my lord. My lord, here my two grounds of challenge on the basis of which I come before, my lord, is, my lord, number one, that there was a serious violation of the principles of natural justice, my lord, and number two, my lord, the authority below, my lord, acted in complete contravention and outside the entire purview of the Real Estate Regulatory Authority Act of 2016, my lord. I will establish that from the statute itself and the rules, my lord. My lord, that, my lord, may I first, my lord, place the basic facts of the case, my lord. My lord, my client, my lord, is a developer in respect of a certain property, my lord, where the complainant has tried to, my lord, obtain an allotment of a flat, my lord. An agreement for sale is entered into between my client and the private respondent complainant, my lord. That agreement for sale, my lord, envisages that the stamp duty payable in respect of the flat has to be borne by the purchaser. That is not done. The agreement for sale is, my lord, insufficiently stamped. This is one of my grounds. My lord, it is insufficiently stamped. They pay me the money that is termed as the total consideration amount to the developer, my lord. Subsequently, my lord, due to various reasons, the project is delayed, my lord. I could not hand over the flat in time, my lord. That is the basic conspectus of the dispute between the complainant and the developer, my lord. The complainant then files an application under, my lord, a complaint rather, under Section 31 of the Real Estate Regulatory Authority Act. My lord, that act, my lord, a copy of the act, may I just hand up?
Audit acted note kore rakho eta niye na.
My lord, the act is on the way, my lord. May I hand up, my lord, a soft?
Thank you.
Grateful to my lord friend.
Yes.
My lord, the application is made under Section 31.
RERA Act, RERA Act. Ani no.
Earlier it was HIRA.
HIRA, yes. Right.
My lord, will kindly directly come to, my lord, section 31 of the Act.
Yes.
My lord, the section 31 of the Act, my lord, will give me 1 second, my lord.
Any contravention of the provisions.
My lord, any contravention of the provisions of the Act. Therefore, my lord, this is not an application which is envisaged under section 18. My lord, section 18, my lord, will kindly come to. Section 18 of the Act provides for a right of a allottee of a flat to obtain refund of any consideration paid to the developer, my lord. Section 18, my lord, we can come to. Section 18, my lord, is not, in my humble submission, envisaged under section 31 of the Act. So therefore, a complaint that is made under section 31 will not possibly, my lord.
Have they alleged that you have violated section 18?
They have alleged, I will show, my lord, I've annexed the complaint petition.
So
Their allegation.
basically, they have alleged that you have violated.
I violated section 18 and I have not complied with the provisions of the agreement for sale. That is their complaint case. That is the sole basis on which they have approached the learned authority, my lord. My lord, despite that, the learned authority proceeds to hear
Section
the
18
matter.
violation comes within section
My lord,
31.
section 18 violation, my lord, I will establish from the Act. My lord, will kindly allow me to place section 18. My lord, section 18, if the promoter fails to complete or is unable to give possession of an apartment, plot or building in accordance with the terms of the agreement for sale, or as the case may be duly completed by the date specified therein. My lord, this is the case that they run. First case, my lord, my first point here is that there is no valid agreement for sale existing between the complainant and the respondent in the proceedings, my lord. An agreement for sale, to be valid in the eyes of law, must comply with the provisions of the Indian Stamp Act. My lord, the Indian Stamp Act, my lord, even the recent judgment of the Honorable Supreme Court in NN Global, my lord, says that in a violation of the Indian Stamp Act, a non-payment of requisite stamp duty, my lord, will vitiate the agreement in toto, my lord. And under the agreement, I've also annexed the agreement. The agreement envisages the stamp duty to be paid by the complainant and not by the developer. Therefore, their default in payment of stamp duty cannot then validate an agreement which has been held by the learned authority. The learned authority holds that it is my responsibility to have the agreement duly stamped, and due to my default, the
All
agreement
these points can be taken before the
My lord,
authority.
I will indicate why, my lord.
I
My
mean,
lord,
you say there's no valid agreement for sale.
Agreement for
One,
sale.
secondly,
Yes.
it was their responsibility to put in the stamp.
My lord.
But
My lord,
these are also subject
these
to.
are all contentious, my lord. I had tried to raise before the learned authority, my lord. My lord, we kindly take to my averment and para 10 of the petition, my lord. There was a hearing that was conducted in respect of the complaint case on the 21st of September 2023, my lord. On that day, my lord, the petitioner before, my lord, was represented by learned advocates. My lord, all these points were tried to be raised before the authority. The authority, my lord, I would say, my lord, had already prejudged the matter to a degree as soon as the points were raised. And there is a video recording of this that is existing with the respondent authorities because, my lord, at the start, it is a video conferencing link that was sent to my client. Through that video conferencing link, my lord, the learned advocates joined, and it was stated that the entire proceeding was being recorded. My lord is aware, in the Zoom platform, it's stated that it is being recorded. In that recording, my lord, it will be evident that the authority had fully prejudged the matter. They did not allow the respondent to place their case at all. And my lord, one of the interim orders that I've sought for, my lord, is production of that video recording as well. My lord, this is a serious violation of the principles of natural justice.
Take this before the appellate forum. The difficulty is in the writ court's hands are bound. Yes, definitely palpable violation. All these we can take. But the appellate authority will have a much wider conspectus. They can also enter into factual, because these are factual allegations also. The duty, the liability of the stamp duty to be paid by them, one. Secondly, whether it's a valid agreement in law, these require adjudication.
My lord, but
why
my
should
lord,
the writ court go into this?
My lord, there is also another question, my lord, before, my lord. Is that an order of the nature that has been passed by the authority could not have possibly been passed in a section 31 proceeding? Can I satisfy, my lord, on that point only, my lord?
Yes.
Section 18, my lord, I've already placed. My lord, section 18, my lord, may I also place the bottom portion of section 18(1)? That is, if those conditions are violated, he shall be liable on demand of the allottees in the case the allottee wishes to withdraw from the project without prejudice to any other remedy available to return the amount received by him in respect of that apartment, plot or building. So, my lord, this is their right to refund. My lord, we kindly directly then come to section 71 of the Act. My lord, this provision requires to be adjudicated not by the authority. My lord, will kindly see section 71, power to adjudicate for the purposes of judging compensation under section 12, 14, 18 and section 19. The authority shall appoint in consultation with the appropriate government one or more judicial officers. The authority cannot, my lord, take on to itself a power it does not have. And this is exactly what has been, my lord, awarded in the impugned order. I'll show from the impugned order. The authority proceeds to direct refund of an amount. The authority has no jurisdiction to do so. My lord, the adjudicating officer has the only one. That is, my lord, will also note the difference in the terminology in the section. It refers to an adjudicating officer before whom a proceeding must be instituted.
In this case, you have been directed to refund.
Refund, my lord will kindly come to the impugned order.
There's a component of adjudging compensation.
Yes, yes, my lord. My lord will kindly come to section 1, my lord, page 119, my lord. That is the impugned order. Lord, even leaving aside the point of principles of natural justice, and my lord, I would humbly, my lord, pray for that order to direct, my lord, to produce the video recording, my lord. It is a gross violation of principles of natural justice.
What is the page number?
119, my lord. That is the order of the competent, my lord,
That is the impugned order.
regulator. Impugned order before, my lord. 21st September 2023, the same day, my lord, that the hearing took place. My lord, the complainant Shushma Yadav, along with her advocate, may I please, my lord? My lord, I will not take, my lord, through the entirety of the order. My lord, will kindly note the bottom of the paragraph, a written response is filed. My lord, the written response is not solely restricted to the stamping of the document. My lord, will kindly note this because that is relevant for the observations that are made by the authority. My lord, will kindly come to page 120. Heard both parties in detail. The case of the complainant is that she booked a flat bearing so-and-so. The complainant's case is set out in full, my lord. The next two paragraphs are the complainant's case only without considering the written response at all. My lord, we kindly come to 121. In the written response dated 18 September 2023, point 2b, the respondent stated that the said purported agreement is insufficiently sent, so-and-so, my lord. That point only is reproduced. And the authority proceeds to deal with that point and that point only as to unstamped document. My lord, we kindly come to the next page, 122. Furthermore, the respondent, my lord, B, clause B, my lord, may I please? Furthermore, the respondent is trying to take benefit of his own default, which is not permissible in law. Here, in this case, the respondent failed and or neglected to register the agreement for sale executed between the parties on 3rd February 2022. No evidence has been submitted by the respondent that he has taken necessary steps for registration of the said agreement, and it is due to the default of the complainant the agreement could not be registered. That is the case, my lord, that is the holding of the authority. My lord, will kindly then they point out that I am in violation of section 13 of the RERA Act. My lord, that will permit the authority to impose a penalty upon me, and that is the extent of the jurisdiction of the authority. My lord, will kindly take C. Chapter 3 of the RERA Act contains the heading Functions and Duties of the Promoter, section 11 to section 18 under the Act. My lord, so and so. Therefore, it is also crystal clear and evident that the intention of the legislator who have drafted the RERA Act was that section 13 should be the obligation of the promoter, and that's why they have placed it under chapter 3 containing the heading Functions and Duties of the Promoters. My lord, will kindly then they discuss, my lord, further on the judgment that I had placed, my lord, that was placed by the learned advocate before the authority in respect of stamping only. Again, none of the other points in the written response considered. My lord, will kindly then take the ordering portion directly. Page 124. Yes. Hence, it is thereby ordered that the respondent shall refund the principal amount of rupees 76 lakhs along with interest. My lord, in my humble submission, my lord, the authority had no authority whatever in law to order this refund, my lord. They are entitled possibly to, my lord, adjudicate on a complaint alleging contravention of the act. That was also, my lord, in the complaint petition. My lord, I will take, my lord, through the complaint petition, not a single averment as to non-payment of stamp duty that is alleged against my client. If that was their case in the complaint petition, yes, possibly. My lord, here may I also point out, my lord, the rules in respect of this act, my lord, which govern the authority. This is framed by the, my lord, West Bengal government. My lord, will kindly take rules, rule 24 only, my lord. I'll only draw my lord's attention to 2 subsections.
Yes.
Rule 24(5), my lord. every complaint shall be heard by the authority on the basis of affidavit and or documents relied upon either in the presence of the parties or through video conferencing as may deem fit and proper. Sub rule 6. As far as practicable, the authority shall follow the Indian Evidence Act in principle. These are the rules of procedure binding.
In this
upon the
case, you had
authority.
given a response.
I had given a response, my lord. That too, my lord, I had taken the point of non-stamping. This was never a ground alleged by the complainant before the authority. This was never a point. Firstly, my lord, sub rule 5 in my humble submission, my lord, makes the authority bound by the pleadings, that is the complaint before the authority. They cannot traverse beyond the pleadings before them. Therefore, the authority, by adjudicating on the
They
stamping
did not
issue,
seek refund.
they had sought refund, my lord. They had not alleged contravention of section 13. My lord, section 13 is a contravention on which the penalty can be imposed upon me, my lord. The refund, my lord, cannot be adjudicated at all by the authority. That is my stand. My lord, it cannot be ordered. Therefore, my lord, the order has to go. It can be adjudicated. If my lord pleases, it can be adjudicated afresh on the basis of the section 13 violation, possibly. There also, my lord, the evidence placed by my client has to be considered as per the rules binding upon the authority. And my lord, now my urgency for coming before my lord is that they are trying to execute this ex facie without jurisdiction order that has been passed against my client. The complainant is trying to execute in order to extort money from my client. My lord, a procedure established by law has to be followed.
Yes, for the purpose of interim order. What do you say?
Lordship, the preliminary point.
The mic is not working. Problem is.
Yes. The preliminary point which has been taken by my learned friend in approaching this honorable court is violation of principles of natural justice. And secondly, what he has taken is that the regulatory authority did not have the power to pass the orders which were passed. Now, I am also without a copy of the
Act or rule?
act. The rule I have.
You can take both, I mean, for the time being.
No, Lordship will require
রেরাটা
that.
আনিয়েছো কি?
Or
আনতে দিয়েছো?
maybe if your Lordship permits, I can come back at 2 with another
রেরা
copy.
বললাম তো আনাতে দিতে। কি করছো এতক্ষণ? রেরা অ্যাক্ট বললেই হবে বললাম তো।
Act to এটা? Lordship will kindly take up section 13.
Place it for me in the meantime.
Yes.
Yes.
No deposit or advance to be taken by a promoter without first entering into agreement for sale. That a promoter shall not accept a sum more than 10% of the cost of the apartment, plot, or building, as the case may be, as an advance payment or an application fee from a person without first entering into a written agreement for sale with such person and register the said agreement for sale under any law for the time being in force. Now, the obligation which is cast is upon the promoter to get the agreement registered. Lordship will consider that the total sale consideration amount it is reflecting in the order is 96,35,598. I have paid 76,02 rupees as per the demand made by the promoter. There is no scrap of paper before your Lordship to indicate that they had ever made or raised any demand requiring me to pay for any stamp duty or the proposed draft, any other draft or any documentation was provided as is generally done. So firstly, there was a violation of this section 13(1), and that was the bone of contention in their argument before the learned regulatory authority, that since the agreement is not registered, the agreement is not enforceable before this before the regulatory authority. Now, Lordship will.
Could the tribunal pass the
Yes.
compensation order
Yes,
under
Lordship.
section
I will
without
show that.
resorting to section 71 procedure?
Without Lordship will take up the regulation for that purpose. The adjudicating authority comprises of the chairperson and the members. with the
Section
West
71 is very specific.
No, Lordship will kindly take up the it is the state
You
powers
got a
are
copy of
also
section 71.
yes.
Please
Lordship,
come to
I'm
that section once. This was never complied with. So that's a palpable error of jurisdiction. The authority itself did it, whatever. Calculated compensation, granted it without this exercise.
No, Lordship, the power in composing actually I am.
You take the book.
Yes.
এটা বইটা দাও।
উনাকে copy
Please take section 17, 71, I'm sorry.
Because
Section 71, he says, has not been complied with. If that be so, the authority was dehorse its powers, for which 226 can be attracted.
there is a provision for the state amendment, Lordship, I have the regulatory authority, this
File your
yes,
opposition.
Lordship, not file my opposition. Lordship will kindly give me 1 day's time because this point was not actually taken up in their pleadings. I was prepared on the other point, and I'm also equipped with the judgments with the other point.
Not a single ground on this.
No, there's hardly any ground
Let
on
me
this.
see if I find the single ground, then I'll admit it indirectly.
1 day's time, Lord.
No, I've hardly that link for prima facie.
Because Lord,
No, for interim order, this is sufficient. hearing.
My lord, paragraph 20, my lord, I've stated the order is without jurisdiction. I have not pointed out the section.
Lordship,
I'll
it has not been pointed out.
The section is
let
not
me-
pointed
let
out.
me come back, Lordship. If I can't satisfy, Lordship will grant
On
me.
what point?
On this point specifically.
Section 71 has
Section 71. I
it is
will come
apparent
back.
from the order itself. 71 has not been complied.
No, Lordship, there is a
There is no reflection of any adjudicating officer.
But of the state, there is a state amendment. Lordship, the state regulation comprises of only the chairperson and the adjudicating members. I will come back, Lordship, only on that point. 1 day's time may be
lord,
granted.
here, my
22nd, I will, if I fail to satisfy your Lordship, I will.
Learned counsel for the petitioner has raised several questions. First of it is submitted that
371.
an application under Article 226 of the Constitution is maintainable, since there is a palpable assumption of jurisdiction beyond the authority of the adjudicating authority, inasmuch as the provisions of Section 71 of the Act in Namta ekটু লিখে দিও. RERA Act has not been complied with by appointing an adjudicating officer under the contemplation of the same. Full stop, next para. Secondly, it is argued that it was the incumbent duty as per agreement of the private respondent stroke complainant to pay the stamp duty for the agreement in question, which was not done by them. Full stop, next para. It is submitted that the dispute raised before the adjudicating authority was not one under Section 31 of the said Act, since an exercise under Section 18 had to be accompanied by one under Section 71 for the purpose of grant of compensation. Full stop, next para. Although apparently a prima facie case has been made out by the petitioner, learned counsel for the state, you are for the private respondent stroke complainant at this juncture argues that there might be in force an amendment introduced by the state of West Bengal to the Act, which incorporates the adjudicating officer as an integral part of the adjudicating authority itself. Full stop. If that be so, it is argued that the argument on lack of jurisdiction under Section 71 is diluted. Full stop. To enable learned counsel for the complainant, private respondent stroke complainant to elucidate the matter further on such count, the matter is adjourned till November 22, 2023, when it will be listed at the top.
My lord, could it be on 23rd?
23rd, top.
Lordship, in this matter, Mr. Biani is appearing for WB RERA, Lordship.
He has come to court.
He is not come today, Lordship, due to
Don't
his
give his
illness,
name.
Lordship.
If he has not come to court, don't give his name.
Lordship.
Give your own name.
Lordship. My lord, the affidavit of service.
I'm for the state.
Affidavit of service filed to be kept under. Yes, yes.
Deeply obliged.
Today I was also not well equipped.
Pardon?
I could not assist your lordship today.
Do it,
I was not well equipped.
Do it on the next day.
Lordship.
46.
Suppose can be completed in 2 minutes or
Yes, 2 minutes.
Man,
Because my learned friend possibly is going to take.
Very well.
my
Excellent.
sofa this call kore.
Short matter is, my lord, the writ petitioner entered into a nomination agreement in respect of a purchase of a flat, which he purchased from a developer. My lord, before that, I applied for an electricity meter and got the electricity meter. Electricity meter was in subsistence. The person in whose favor the nomination agreement was entered into, that person although paid initially, but thereafter the entire consideration was not paid. The nomination has been cancelled. Criminal proceedings are pending. They have trespassed into the property. And my lord, now at their instance, my meter has been cancelled and their meter has been installed. That is my allegation.
Ma'am, I have to take instructions on this matter, lordship. Just now I have been told that. So
Our service has been affected on the.
my sofa my sofa CSC has obtained the
May I file
copy.
the affidavit of
Some
service?
instructions are required.
Yes,
lordship.
how can you get his connection disconnected? Indicate. Yes.
My lord, on 14th of March 2015, a nomination agreement was done. This flat
Private dispute, I'm not going into.
No,
Maybe a private dispute, yes.
it's an admitted fact. They have annexed those nomination agreements.
But they were enjoying electricity. How can at your behest it be disconnected?
They put me in possession on 1st of April 2017. I have possession letter issued by the developer of that premises saying that I am put in possession on 1st of April 2017. Now, after that, my lord, the loan of that property was transferred in my name by them. I am paying that loan. They had an electricity connection. I am paying electricity bill. I have proof of those payment as well. That I was in the possession, I was enjoying the possession, I was paying the bill of the meter which was in their name. But in 2021, there were some disputes among between us. And I will also show that we have also paid, my lord, the entire nomination amount which they are saying we have not paid. Then, my lord, they have cancelled.
Have been enjoying electricity from their meter all along.
From their meter.
Now what happened?
But after 2021, they started threatening us that everything has been done, but electricity meter is still in our name, so we'll get the connection cancelled. Thereafter, my lord, that forced us to apply for a new connection because, my lord, we were in settled position of the flat from 6.5 years.
No, you cannot get their connection disconnected.
Lord, we did,
If they disconnect it today,
Yes.
they can surrender that connection. Then you are entitled to get electricity
Lord, we
connection.
applied for a new connection in our name. We did not pray for a disconnection of their meter. My lord, that was granted. My lord, they have not annexed any order of their disconnection. My lord, since we were
At present, there are 2 electricity connections there.
since we were in the possession of that property, my lord, under
There are
section
2 electricity connections, one in their name.
Though I have not been instructed as it appears from the submission, but there is already an existing connection in the name of my learned friend.
No, but that has been
But-
disconnected.
But that has been, and he is asking for the new connection.
He
Take
has
instruction
already
during
got-
recess. Dr. Shara, take instruction during recess whether their connection has been disconnected. I'll direct that to be restored. After that, if they disconnect, if they
Must-
surrender, only then. we can-
Yes, because until there is already an existing service in the said premises, in the same premises.
So
There
take
cannot be
instruction
two
from your
connections.
officers. What was the role of your officers in this? Take instruction during recess. We'll come back after recess. Continue
But
with
probably at 2 p.m. your lordship have got another.
very short correction of an order.
Oh,
Lord, may I just disturb your lordship once?
Yes, Mr. Biani.
My lord, I was unwell, have not come to court, I've just joined. My lord, my item was 45, my lord. Before, by the time I joined, lordship has passed an order.
তুমি ছিলে যেটা নয়ন বিহানি বলে
My lord, I do not add submissions to
whatever
make.
order has been passed now you cannot do it.
My lord, if I may.
Lordship.
taken up at 2:30 minutes. I have a continuing matter.
Then we'll take it up on Wednesday. Wednesday. Till Wednesday. তাহলে একটা ইয়েতে the matter is taken up for hearing full stop in order to enable learned counsel for the WPACDCL CSC Limited to take further instructions in the matter. Let the matter stand adjourned for the day.
Can it be on Thursday?
Why? Come back on Wednesday. Take instructions.
Because tomorrow is a holiday, your lordship knows that whether I can take the instruction or not.
Sir,
That's why I said-
Take it today.
My lord, if I may, this is the next matter, my lord. At number 47, humbly praying for an accommodation. A new set of councils have been appointed, my lord.
17.
47.
47.
Next week, my lord, kindly.
47 at order record.
And 65, my lord. Similar.
Only 47.
47.
On the prayer of learned counsel for the petitioner, the matter is adjourned for the day.
For the week, my lord.
For the week.
Grateful.
Jalpaiguri Circuit Bench matter, item number 1.
My lord, there will be a correction, my lord, in the order.
What correction?
My lord, in the reference portion, my lord, before in the matter of,
Yes.
my lord, it will end as, my lord, instead of Indian Penal, it would be Indian Penal Code read with, my lord, section 6 of the Protection of Children from Sexual Offences Act, 2012.
In the order dated.
And, my lord, there is another correction. In the next page, my lord, in paragraph 4, in the fourth line, my lord, though the amount has been mentioned as rupees 10,000, in words it is mentioned at 20,000.
It will be 20,000.
My lord, it will be 10,000.
Words will prevail. In the order dated September 22, 2023, comma, due to bona fide inadvertence in transcription, comma, in the caption, comma, after the word double inverted penal, double inverted close, the following will be added, colon দিয়ে double inverted মধ্যে capital C code, comma, read with section 6 of the POCSO Act
2012.
2012, double inverted close, full stop, further, comma, in paragraph 4 of the said order, comma, instead of rupees 10,000, comma, as transcribed in numerals, comma, it will be read as rupees 20,000. এটা নাম্বারে করে দেবেন, rupees 20,000 double inverted মধ্যে, which will tally with the amount as transcribed in words. Full stop, let such correction be deemed to stand incorporated in the order dated September 22, 2023, and this order be treated to be a part of the said order for all practical purpose.
Grateful.
Sorry for the mistake. Grateful. Yes, sir.
48.
Appearing on behalf of the petitioner.
Yes.
Effective service had not been completed upon the respondent, private respondent, my lord. Highly praying for not this week.
On the prayer of the petitioner, comma, his service has not been effected, comma, let the matter stand adjourned for the week.
আমাকে একটা কপি দিও আমি সিএসসি ও পাইনি আর।
Yeah. 49.
None appears at the time of call. Let the matter stand adjourned till the next monthly list.
Right. 52.
50, my lord.
50. 50.
But my lord, today is the sale date. That is why it was mentioned by my junior in the morning, my lord.
Those are to appear on 22nd.
Yes, because today is, my lord, the sale date. Today is 20th. That is why, my lord.
Wait for that. That's why it was granted.
My lord,
No, my lord, today
yes,
is the
my lord,
sale date.
that would be better,
20th.
my lord, if it goes on 22nd, my lord, because the bid portal, my lord, it will open at 4 p.m. because sale is being
But I am
conducted
praying
through
for
an
a
agency, my lord. So that
4
we
p.m.
will
today.
till 4 p.m. My lord, bid has been
But
the
I am
chance of
praying.
taking bid, my lord, that has been closed on 18. But my lord,
But
sale
then
is
it has to be taken up all the more today.
Yes, my lord, because kindly see,
Lordship,
my lord, it is.
as of now, the bank does not know whether we have received any bid or not, my lord, because the portal will open at 4 p.m.
Lord,
Then
that's
only
a
we'll be
different
able
issue, my
to
lord.
affirm, my lord.
Lord, that's a
That
different
whether
issue.
there is any.
Let us take up
May I
that.
only place one document?
Item 50.
Yes.
Lord, may I only place one document to show, my lord, that is the sale
একটা লাইন
notice.
প্রথমে দেখে নেবেন অধবাবু, although the matter was fixed on November 22, 2023, on the mentioning of the petitioner due to urgency, comma, since the matter has been called on in due course today, comma, and both sides are present, comma, the matter is taken up for hearing as a motion. Yes.
Now, only kindly takes up, my lord, annexure P13, that is page 52. My lord, there is a clear violation of rule 86. My lord, date of issuance of my lord, the sale notice is 30th of October.
Unreadable. What is the violation?
My lord, there has to be a clear gap of 30 days.
Yes.
My lord, issued on 30th of October during the vacation. My lord, today is the sale date. So, my lord, there is clear violation. It's within 20 days. And my lord, my surface
My lord, this is the second sale notice, my lord, 15 days, my lord. This is the second sale
My
notice.
surface application is
Lordship.
pending. Just prior to that, my lord, page
This second sale notice is
Lordship, this
15
is
days
second
then.
is 15 days, your lordship.
That point goes. What is the other
Lordship.
point?
51 kindly sees, my lord. My surface application is pending. And my lord, kindly sees the next listing date. But I have no recourse.
Are you enjoying any interim order from the
No,
from
your
the
lordship.
tribunal? Then
No, my lord, kindly
where is the bar in the sale going on?
My lord, kindly appreciate, my lord, I will not have an opportunity, my lord, even to present my case. It's not a case that whether I have
You have
filed-
applied before the surface.
Yes, I have
failed
applied,
to
my
obtain
lord,
any
my
interim
lord,
order.
in the meantime, my
When
lord,
did you apply under the Surface Act?
my lord, kindly see, this is the page only.
When did you apply before the tribunal?
My lord, it is on 10/2/2023, my lord.
What were you doing for so long? Why didn't you obtain any interim order? At the 11th hour, you were coming to court and asking for
After 13/4, my lord, I can only go before this tribunal.
10th of February, you have filed your application before the tribunal. You did not prepare stay.
Tribunal did not sit, my lord. This is DRT2. This is the problem.
From February?
My lord,
Definitely not. You are making an incorrect
No,
statement.
my lord, kindly one. First sale notice was there.
10th of February, you filed the application before the tribunal. What prevented
I
you
will
from
just-
making the
my lord,
any?
there was a first sale notice which we challenged. My lord, which we challenged. Then that was set aside, my lord, because they could not proceed. Now, my lord, this is the second one. My lord, all I am, my lord, is seeking is a protection, my lord, till the time my matter is heard. My lord, I can also approach under 17A, but for
You
that
have approached.
no, my lord, not under 17A. 17A is before the DRT. Your lordship knows.
17A, you did not take recourse to till
No,
now.
my lord, I could not because this is only in the October.
What do you mean by
My
could
lord,
not?
no, this
DRT is also
30th
not sitting.
My lord, kindly says this is only 30th October during the vacation, my lord. This is only within the vacation. That is why, my lord,
My
I am
lord, no
seeking for a
ground
short
has been
protection.
taken, my
Challenge
lord.
this subsequent sale notice before the
Yes, this is, my lord, this is under challenge. This is the
You
subject
say
matter
10th of
application.
February you have
No,
made the
10th
application.
of February was, my lord, my section 17 application, which was
You say you did not get any time to challenge this last sale notice.
yes, last sale notice because this is 30th October. And my lord, today we are on 20th.
The tribunal was closed for this period.
Yes.
When did it open?
The tribunal is not yet sitting. That's the main problem.
This is DRT2.
Yes, my lord,
DRT2.
DRT2. That's the problem,
My
my
lord,
lord.
this is DRT2, my
I have
lord.
nowhere
I'll
to
only
go.
beseech your lordship, my lord, to kindly take up this matter day after tomorrow. If, my lord, there is no bid, my lord, then it automatically becomes infractuous.
Yes.
My lord, they have
If
only.
there is any
If
bid,
there is a bit, my lord.
My lord, then we will proceed on merits here before your lordship.
proceed on.
Proceed on merits, your lordship, if your lordship wants to.
No,
And
don't take any action on that. Don't proceed further.
my lord, till day after tomorrow, we will not, my lord.
No, not till day after tomorrow.
My lord, we do not know as what is the fate of the bid, my lord. That is not clear to us because at 4 p.m. the portal will open, my lord. Then we will get to know whether we have received any bid or not.
Very well. Learned counsel for the petitioner contends that although a challenge has been preferred before the Debts Recovery Tribunal on February 10, 2023, the sale notice against which the present writ petition has been preferred now was issued only on October 30, 2023 without leaving the requisite period of 30 days. For next para, it is contended further that the petitioner did not have any opportunity to move the DRT against the said issuance, since the sale notice was issued during vacation and the DRT2 where the matter is pending, is not functioning at present. Next para, learned counsel for the bank submits that this is the second sale notice for which the statutory period is 15 days, which was kept before the date of sale. Next para, it is further argued that the bank is not certain as yet as to what will be the fate and whether any bids will be received, since the time for opening the bid is 4 p.m. today. Next para, it transpires that in view of the circumstances indicated above, since the sale notice was issued during vacation and the DRT2 is not functioning, the petitioner did not get adequate time to seek a stay with regard to the same. For the ends of justice, the respondent bank is restrained from taking any further steps after opening of the bids insofar as the sale notice is concerned, comma, to finalize the sale in any manner, comma, till December 8, 2023 or until further order, comma, whichever is earlier, full stop. The matter shall be listed on November 28, 2023 under the heading upgraded matters for passing further orders.
But
I'm
only
grateful,
one
Sir.
indulgence made me on 30th, 20th,
30th,
29th. I am not here, my lord.
November 30.
If the meantime, my lord, if we do not receive any bid, my lord, they can
You
get
just
the matter.
inform it on the
Lordship.
next date. I'll
It
record
becomes
that.
infructuous, my lord.
Yes.
My lord, affidavit of
Grateful,
service.
Affidavit of service.
Lordship, I'm appearing for the state correspondent led by Mr. Shantanu Kumar.
Wait, please give your names. What happened to your hand?
Lordship, I'm met with an accident, Lordship.
Bike?
Bike.
Yes. Right.
Grateful to your lordship.
Next. 30th as well, 28th, 30th. November 30th, upgraded matters here.
My lord,
Fif-
item number 51.
Dako?
52.
Yes.
51.
51 কি হলো? কে? Somebody mentioned in the morning. Surjo Maiti, Mr. Surjo Maiti mentioned.
My lord, I am appearing for the one of the private respondents, my lord. No copy has been served.
Ask for a copy, right to
Very
him.
well.
I am
It has been fixed when? কবে? The 22nd at the top. Wednesday. Come back on that date.
23rd.
It has already been fixed in the morning.
Great.
Yes.
52.
My lord, I appear on behalf of the petitioner. My lord, this matter appeared earlier on the Saturday. We appeared in this matter and the affidavit of service was filed.
Right.
My lord, we tried to get the information who was the learned advocate who was appearing on behalf of the state, to which we were informed on 19th October, on the last day.
Yes.
We tried to serve it on the office of the government pleader. My lord, what happened was we could not find anyone, so we were informed that we can serve it through email. We effected email service. My lord, then again when the court reopened on 16th November, we tried to serve it again physically.
The previously you had already served.
Yes, my lord.
What is the matter? Move the matter. They are not appearing. Let us hear the matter.
My lord, I am led by Mr. Mondal.
Yes, yes. Yes, what is the matter? You have already filed your affidavit of service. Since it was Saturday, there was a resolution. I did not take up the matter. Move your matter today.
Lordship, on 21 December 2022, my lord, my vehicle was with some timbers. My lord, forest beat officer, being the respondent number 4 here in my lord, confiscated that. Thereafter, my lord, confiscation proceeding was started. My lord, your lordship will find the order. My lord, kindly comes to page number 28. My lord, forest beat officer, my lord, this is the report regarding, my lord, the timbers. My lord, here it is stated that, my lord, 2 persons from whose land, my lord, those timbers were cut, my lord. It was Raiti land, my lord. And thereafter, due to their illness, they have sold. My involvement is, my lord, I am the owner of the vehicle, my lord, only the owner. And my vehicle was carried due to, my lord, only for carrying purpose, my lord. Thereafter, my lord, kindly comes to page number 35. My lord, this is the order of confiscation proceeding, my lord.
Your vehicle was carrying the timber. Naturally, it will be confiscated.
Yes, my lord. But my lord, my ground over here is, my lord, those vehicle are not the, my lord, forest produce. My lord, those are cut from, my lord, Rahati land, as my lord stated in the report by the forest beat officer, that appearing in page number 28, which I have shown to your lordship. Now, my lord, that vehicle has already been confiscated. My lord, thereafter no appeal, neither, my lord, revision was preferred from our side, my lord. We do not have, my lord, other alternative except, my lord, approaching your lordship for.
No, reason order was passed.
Yes, my lord.
There is no provision of any challenge against this.
My lord, we have not challenged. That is why, my
There's
lord,
an appeal.
there is a provision of appeal. So, my lord, now there is no scope to, my lord, file that appeal. My lord, what I am praying, my lord, kindly.
Bypass that, you cannot take out.
No, I do not want to bypass, my lord. I want to approach over there. My lord, kindly gives me that liberty to approach there. And in the meantime, my lord, my vehicle may not be sold.
No, how can I give you that liberty? I mean, if the
My
if
lord, already
time has already lapsed.
been lapsed.
So how can the High Court 226
My lord,
court case?
except that I do not have any other alternative, Lord.
No. Let us see what has been held by this. Your Rayati point was taken there.
Yes, my lord, they have.
How was it dealt with? Let us see that.
Yes, Lord.
No, this falls within forest produce as per the order.
But my lord, Rayati land can't be fall, my lord, in forest produce.
Forest officer did not see the timber being cut from us Rayati land. It was your statement, probably your driver's
No,
statement.
no. Forest officer, my lord, measured the, my lord, every cutting, my lord, timbers. And it is evident from the, my lord, report.
How can the court grant you that? What is that limitation period for that?
30 days, my lord.
Then you appeared there. What is your reason for not preferring an appeal?
But my client was not known to this, my lord. Thereafter, much later, my lord, they have come. Now process has already been, my lord, went ahead.
Cannot be reopened now.
My lord, kindly sees once, my lord, section 69.
Yes. Presumption is against you.
But
69?
Yes, my lord.
Read 69.
When in any proceeding taken under this act or consequence of anything done under this act, a question raised as to whether any forest produce is the property of the government, such produce shall be presumed to be property of the government until the contrary is proved. My lord, that is what my ground
You also made an apology, virtually admitting your guilt.
not by me, my lord, not by me, the owners. The owners from whose land it was cut.
No, you are Nimaide. See para 3, page 35. You are Nimaide, you are the petitioner, you are the owner of the vehicle. Nimaide came with an apology prayer to release the vehicle, claiming that he did not know that a transit pass is required. Tell him whatever I told you. I don't want a repetition of the entire thing.
আমাদের কাছে আর কোনো আদার অল্টারনেটিভ নেই এক্সিকিউট করছেন ডিস্ট্রিক্ট কোর্ট বলছে প্রিজাম্পশন ইজ এফেক্টাস দ্যাট ইজ আমাদের পজিশন
পেজ 28 টা দেখি
হ্যাঁ
হ্যাঁ
পেজ 28
Yes.
My
Riot of a private land sold forest produce. You are carrying that. You asked for release of the vehicle and with an apology. Refused. No appeal preferred. What can be done by the writ court?
Well, since I missed the bus because 59C and D, I failed to avail.
And writ court cannot extend the time. If
Either
that court had power, definitely you could approach that court and the appellate forum. Then you could approach. Is there any scope of any condonation in that provision?
no, that is why I do not have any option
226
except
cannot.
226.
We cannot improve the situation in 226. That is a difficulty.
Now the question is, what I'm on. If my lord, I cannot be, my lord, our constitution is not saying that that day I will be no justice will be given. On the question of natural justice, my lord, your lordship can entertain a 226.
This will be unnatural justice.
Now, my lord, if your lordship allow me to do the matter on merit for only on 2 points.
I cannot enter into it. Rayati land, trees, timber cut from Rayati land is not forest produce. That is a primary argument.
No, my lord, I will not argue that because the definition of forest produce is that if it is forest and not forest, then also, my lord, that will come under that. But I will have 2 points only. One is, kindly come to page 28. It was the inquiry report
Yes,
by
it was
the
being
their
placed.
officer. Your lordship has already
He was
gone.
placing that. Yes.
Now, in the order of the judgment, my lordship will not found that this fact has been discussed with. That it was Ratland, the person's wife was ill, so that everything was done. Those thing was
That
not
is immaterial.
now. Second point I'm taking is kindly come to 59 subsection C.
He has given a book. Yes. 59C. All right.
59C. No, 59A, subsection 3.
Forest Act.
Forest Act. That is the
West Bengal
provision for confiscation.
59A.
59A, subsection 3.
There is the 59A in.
This is.
Oh, yes, yes. I'm sorry. Yes, got it. 59.
A, the power of confiscation is there.
Yes. Subsection 3.
Subsection 3.
Right.
What I am on is,
yes,
the word used is may. Where any timber or other forest produce, which is the property of the state government, is produced before an authorized officer under section 1, and the authorized officer is satisfied that a forest offense has been committed in respect of such property, he may, whether or not a prosecution is instituted for the commission of such offense, order confiscation of the property together with the tools, ropes, chains, boats, vehicles, and kettle used with order. So what I am on is that it is may. So wherever may I try. Wherever there is a may, that includes may not. So the legislative intention where it is may and where it is may not, in my respect to submission, that will depend on the gravity of the offense. But here in this case, it is the discretion. So, in my respectful submission, here it's a case where, a person's wife was, ill. For the
not
sake,
your wife.
Not my wife.
So you cannot take advantage of that.
Now, if, what I'm on
you
is.
were rather taking advantage of the illness.
I was.
His wife was ill, he sold the property, you took the property and you were transporting it.
So, I was only.
You exploited that advantage.
I was only transporting. So,
you exploited her illness.
He asked me to do that. I just being for
take
that.
Advantage of that. You are not the riot whose wife's illness, due to wife's illness, is sold.
So, all that mistake I have done is without any proper chalan, I have carried that thing.
Absolutely.
So,
that is the mistake. That is the mistake for which you have been hauled up.
So, neither I was a beneficiary to anything, neither
you are not a beneficiary because you were caught. Otherwise, you will be dead beneficiary. All those timbers if you sold.
I was not solding, because the beneficiary is the person who.
Learned counsel for the petitioner contends in his usual fairness that although the time for preferring a challenge against the impugned order dated March 17, 2023 has elapsed, an opportunity may be given to the petitioner to prefer a challenge before the appropriate appellate authority. It is submitted that Section 59 capital A within bracket 3 of the Indian Forest Act, 1927 as amended in West Bengal, uses the word within double inverted may in respect of confiscation of the offending vehicle. It is submitted that the gravity of the offense is to be looked into where there is a discretion conferred on the concerned officer. In the present case, due to the illness of the wife of a riot, he had sold certain timber which was being carried on the vehicle of the petitioner. Hence, keeping in view that the offense was light in nature, comma, the discretion ought to have been exercised in favor of the petitioner. Push up. It is further argued that as per the forest beat officer's report annexed at page 28 of the writ petition, comma, there is reflection of the fact that a riot had sold the trees in question which were standing on his land, comma, for the treatment of his wife. Push up. Hence, comma, a sympathetic approach ought to be taken. Push up. Next para. Upon hearing learned counsel, despite service, none appears for the respondents. Full stop. The affidavit of service filed today. Despite service, none appears for the respondents. Full stop. Next para. Insofar as the time limitation is concerned for preferring a challenge, comma, the same is over, and Article 226 of the Constitution of India cannot be used as a means to rectify such error, comma, since there is no scope of condonation as such under the relevant statute. Full stop. Next para. Inasmuch as the contention of the petitioner is concerned, comma, even if a riot of a land had sold the timber in question on the ground of illness of his wife, comma, for her treatment, comma, the petitioner, comma, who is the owner of the vehicle which was carrying the said timber, comma, cannot take advantage or sympathy for such situation, comma, since the petitioner would have been a beneficiary, comma, unless his vehicle was confiscated, comma, of such unfortunate predicament of the riot in question. Full stop. Next para. Inasmuch as section 59A within bracket 3 is concerned, comma, the expression double inverted may does not give a charter on the offender to claim any sympathetic view, comma, since the discretion has been used rightly by the officer concerned in confiscating the vehicle. Full stop. That apart, comma, it is seen from the impugned order dated March 17, 2023 that an opportunity of hearing was given to the petitioner, and the petitioner, comma, as recorded in paragraph number 3 thereof, comma, had gone with an apology prayer to release the vehicle, claiming that he did not know that a transit pass is required for transportation of timber. Full stop. Next para. It was also recorded that he did not submit any document related to the ownership of the vehicle. Full stop. No other aspect was argued as such. Full stop. Section 69 of the Indian Forest Act 1927 raises a presumption that forest produce belongs to government, comma, which has not been rebutted in the present case. Full stop. Thus, comma, in any event, comma, there is no scope of interference with the impugned order. Accordingly, WPA 25528 of 2023 is dismissed without an order as to cost. I'm extremely sorry. You tried your level best, but nothing. বইটা ফেরত দাও। You learned junior also, both of them started arguing very well, but yes. Next.
53.
53, my lord, I have got instruction to appear on behalf of WB ACDCL. My lord, let a copy of this application.
Why in every matter this happens?
We have not received, my lord, because
they serve copies beforehand. In every matter, copies are served.
It has been sent, but my lord, I have also not get the track report.
Come back on Wednesday then.
আমাকে একটা copy দিন। I'm grateful.
Not today.
I have 54, Lordship. I am for the petition on behalf of
It will
Mr.
be called on.
54.
Sorry,
Yes.
I am for the petition and Lordship. I am praying for not this week due to a service not complete.
Service is not yet complete. On the prayer of the petitioner, that the matter stand adjourned for the week.
Grateful, Lordship.
$55.
I'm for the petition.
Yes. 55 and 55 itself, there are two matters.
No, 55 and 56. The matters are similar. Lordship, matters are similar. Petition is same.
দাও ওটা দাও দুটো দেখিয়ে দাও বোর্ডে
56.
55 and 56 I'm taking up together. The respondents have a fascination for the surname Bhattacharya. You and Mr. Shashank Bhattacharya both. Yes. Yes, what is the matter?
In this matter, Lordship, I'm for the petitioner, Lordship. The petitioner was awarded with a contract to take the car parking contract from the Bardhaman railway at Bardhaman railway station. It was issued in the year 2021 March. The contract period was for 3-wheelers, rickshaw, and 2-wheelers for the period of 3 years. Now, what happens?
This for collecting the parking fees near the vicinity of the station.
Railway station.
Right.
Now, what happens, Lordship, that we were supposed to make the payment to the railway authorities after collecting the parking. There was a deal. Now, in the year 2021, 5th May, because of the intervening of the pandemic, there was a government notification that all the inter-state railway were all stopped. All the activity of the railway stations were stopped, so there was no parking. I have annexed with my annexure page 17 onwards, Lordship. Now, this continued till October 2021.
Right.
Now, thereafter, Lordship, in the month of November,
So your payments were waived.
They have not said anything. The government issued circular and the guidelines under the Disaster Management Act.
No railway movement.
No railway booking. So actually there was no movement of the public also. So there was no parking also there. So there was no generation of the revenue there also.
Right.
So I could not pay the money.
Right.
Now what happens, Lordship? The government leaves the restriction. It was lifted on with effect from 1st November 2021. Then I informed the railway authority that scene is said to be lifted. So from 8th November 2021, we will start the parking. That later I have annexed, we have informed the railway, is on annexure page 40, annexure P6. Now, after receiving the letter.
What is the date of that letter?
This letter is dated 1st November 2021.
Oh, that date itself. Very.
And we have said that we will reopen from 8th November because we have to organize and arrange collect everything. Now, the railway, they issues the demand notice, that is annexure P7. And they claim the money between that period from 11 July 2021 to 10 January 2022.
To 10 January 2022. What happened from 8th November onwards?
We started.
You started paying?
We started. We have not denied that after November, we are not denying.
Then why did they claim till January 10th?
Because the money was not paid at that time. So that was the collections were not
on
just
1st November 2021. Oh, that's very yes.
So we received a notice on page 42. That is 4th January 2022. Now this is also very interesting. Lordship will find from the letter that they are demanding the money from 11 July 2021 to 10 January 2022, and the letter is dated 4th January 2022.
Yes, that is what I was wondering.
Yes, that is I was also wondering that how could they give advance notice without understanding. Thereafter, we respond to that demand notice, page 43, annexure P8. And we say that because of this pandemic and because of the Disaster Management Act and rules, we could not pay and we are not unable to pay the money. But we say that we'll pay from 8th November 2021. That is the last paragraph, page 43, annexure P8, Lordship, you can see under the above circumstances. Now the railway, we have given this letter, 2-3 letters are there, different departments. Now the railway again issues notice on 25th January, sticking to the same claim. Now we challenge this in a writ petition. That is still pending. It is not. It was in the running in the list, but because of the change of determination, it could not come up. It was pending. Now, what the railway does? Railway again issues a fresh notice on 21st August 2023. That is page 48 and actually P11.
Page 40.
Page 48.
48, right? Yes.
And then they come with this claim without even considering my representation which was pending, and the writ petition was also pending. They were served earlier without disposing of my
So that writ petition is still pending.
in this petition, it's never been called up. Now, this was a fresh claim, and one thing more, we came to know that my period of contract was till 10th April 2024. And what the railways had done, I've averred in my paragraph, if Lordship may kindly see, paragraph 15, that we have come to know that in the month of February 2023, without terminating the contract agreement, they introduce a new person. That is paragraph 15 I mentioned, to one Shubha Chakraborty. And we didn't receive any information in writing or any intimation that we have terminated your contract also. Now, this subsequent demand notice,
So at present, you are also collecting, he is also collecting?
No, we are not collecting. This is because after the demand notice, we stop functioning. I'm not performing that because now that I've been saddled with such a huge amount, and without disposing and without seeing that this was not within my control, this pandemic situation. Now they have demanded. We have given a representation, not being considered. Earlier it produces pending Lordship. This is
when did you stop performing?
Just a minute. Can I just? Sorry.
Continue business, although yes, tender was terminated on 3rd March 2020.
My client's instruction is that after receiving the demand notice in 2022 January, he stopped collecting the rent.
You say that you have not been terminated. So why did you stop?
Officially, I have not been terminated because in Lordship knows that
if you have not been terminated, you could have collected.
So I was even not allowed to collect. Also, I was just waiting for my response to my letter. That whether they will consider whether I'm.
The plinth of your argument is that regarding during the pandemic period, you could not have collected, but they're asking for those dues. And on the basis of that, they have not terminated, but appointed somebody else.
These two issues are the Lordship. And my earlier writ petition is also pending, which they had the knowledge. And
what
again,
is the second writ petition regarding?
This is the second writ petition.
55 and 56.
This is the second notice which is given in the month of August 2023. My first writ petition was in the first demand notice of January 2022.
No, there are two writ petitions which are pending before me today, 55 and 56.
That is the second parking. There were two different parking contract. One was regarding the three-wheelers.
So far, the second current writ petition.
So let us hear them then.
Lordship.
This is the point, yes.
So far, the current writ petition is concerned.
Yes, Mr. Bhattacharya, please take the mic. Current writ petition, yes.
Your Lordship, kindly come to page 48. What is his challenge? He has challenged the notice of claim. That, my lord, I have not yet received any instruction. Your Lordship can direct the authority to dispose of that, my lord. He has made a representation. Or, my lord, give me opportunity to file opposition. So, for this writ petition, and prayer is also that. Your Lordship, kindly come to his prayer. Issue a page 11 of the writ petition. Issue a writ in the nature of mandamus and or order or orders and or directions, thereby commanding the respondent to withdraw, cancel the notice. This claim which has been claimed, that has been cancelled. According to this, he has not challenged the termination. He has admitted he is not there. He is not continuing.
He is challenging the claim.
Only that claim.
But Mr. Bhattacharya, if there was during pandemic period, admittedly there were no COVID restrictions.
So for this admitted period, my lord, if that is there, my lord, your Lordship kindly direct the department to consider his representation and pass final order. Or, my lord, your Lordship give me liberty to file opposition to that. This is my respect.
And regarding the without terminating him, you have appointed somebody else. What is
that is not the subject matter of this petition. No prayer, neither the subject matter. Your Lordship kindly only relief is there. What is not prayed, he cannot get any relief, my lord, in the petition. That is also, my lord. He has not challenged the termination.
But Bhattacharya has to add something.
If the first writ application fails, then the question arises my writ application.
No, your writ your writ application is on same grounds. That is regarding only a.
This is the second. Yes, this is the second notice. The first point is this, my lord. That
no, in both he has challenged the second notice, if I get it correctly. Mr. Sukumar Bhattacharya's writ is regarding one type of vehicle parking agreement?
No, first notice. That was the challenge of first notice.
Oh, that was the first notice. 56 is the second notice.
Second.
What do you have to say regarding second?
Second notice.
No, he's getting confused also.
You're confused.
Yes, first,
You and Mr. Bhattacharya on same footing as far as respondents are
Yes,
concerned.
yes.
Yes, on 12, this is the challenge. This is the challenge of notice issued on 22nd, 21st August 2023.
Yes.
2020.
Yes.
Since, Malad, can you see, just have a look of the notice, Malad. Since they have failed to pay the demand, Malad, this notice was issued.
No, during pandemic period, there were COVID restrictions. How could you charge for that period?
The which people are entitled to get the relief of COVID restriction, that has been clarified by the railway.
There was no railway movement. How could they collect parking fees?
Yes, there is but not the period as claimed by the petitioner, my lord. A certain period was given relaxation.
So one option is to direct you to reconsider the claim. Then I have to set aside this demand notice and say that you have to reconsider the claim by taking into account his contention that during the COVID period, you have to take that into consideration. You have to factor that in and reassess and then claim make your demand.
We are not entitled to get any relief under the COVID period. In view of the findings and observation,
yes,
guidelines given by the railway authority.
Yes.
Then affidavit. I don't know.
That is given by the railway authority. We have considered this aspect.
Yes.
No, আজকেও ফোন করেছি আজকেও চেক
Railway authorities cannot affect third-party rights.
The third party right has been given after giving due notice. As per terms and condition of appointment of a tenderer, my lord, if you fail to pay the amount within a certain time, another notice has to be given. And notice has been given as per the clause of the terms and condition. As such, my lord, have never challenged.
The COVID restrictions you have to take into the entire country came to a standstill.
That is one aspect, my lord. That is one aspect.
That is the only aspect I'm asking you. The others you have complied.
During the COVID period,
yes,
they could not be. They are praying for relaxation. They have never challenged that their termination is illegal and invalid.
Termination, as Mr. Bhattacharya rightly pointed out, it has not been challenged.
Not in this application.
We are not on termination. We are on the claim itself.
Only the claim, madam. Only the claim. So what I am suggesting, it is also their prayer to consider representation, since there is a railway board circular whereby and whereunder it has been clarified who are entitled to get the benefit of relaxation for not collecting the dues from the passengers.
Is that with you?
Yes, yes. Yes. It is the 15th September.
Because I can direct affidavits. The difficulty is, even if I direct affidavits, it will be a fact-finding inquiry. Ultimately, if it is sent down after all this exercise,
that is why
it will be meaningless to all of you.
Because termination not challenged, only challenge. That is, I clarify one second, right? Only claim according to writ petitioner, this is.
Mr. Bhattacharya is saying there is some circular. If he has that,
yes, I have come with this.
Roman 2.
Roman 2, my lord.
পড়ে শোনান। That will be applicable.
If they come under the purview of this circular, they will be available.
No, Mr. Bhattacharya, this is required to come on record. I'll direct affidavits. This has to come on record. Because here it is stated that no relief shall be considered for those contracts for which the price bid was submitted after 25th of March 2020.
Factual matrix, it has to be decided.
We will consider the veracity of this also. You disclose this in your opposition. I'll direct opposition in this.
Lordship, one thing.
But in the meantime, please don't act on this claim.
No further action on the basis of
this demand.
On this demand.
The money recovery, don't take any coercive step.
Only one humble submission, Lordship. Lordship may kindly see there when they awarded me the tender, they have mentioned that the agreement not executed will be given after execution. That agreement my client has not yet received. So they let them disclose in their number 2, Lordship. They are saying that I have regarding termination of not challenge. That is true. In the prayer C have said to consider my representation. Now, if
termination has never been challenged, not even
it's not in the prayer. In the paragraph I've disclosed, and in the prayer C have said to consider my representation, but in the representation I've mentioned this thing. If you Lordship kindly have a glance to page 52, I've said that. Then how could you issue the
I have all the documents to show that.
In the writ petition, you have not challenged. What can be done?
No, in prayer is not especially mentioned there, but paragraph C is there, Lordship. Prayer C is there to consider my representation.
Even in the late,
this is a representation which is appearing on page 50 onwards. No, Lordship, I mentioned that in paragraph 9 and 10.
Even at the time of moving the second writ application.
11, paragraph 11 of my letter. Let them file their affidavit to all this.
The second writ application file challenging the notice, wherein it has been categorically mentioned that your service has been terminated, your tender has been terminated.
Where?
Kindly page 46. That is the notice under challenge. Only notice under challenge in the page 46, paragraph page annexure P9. Page 46, paragraph annexure P9. Next writ application. Contract for operation of two-wheeler parking stand at Bardhaman railway station has been awarded to you for 3 years. You have paid hence fees up to 18 June 21. Due to non-payment of license,
it's not mentioned there.
For the period from 7 days, notice was issued to you on auto in exercising of point number 8.
Hence, termination notice was issued to you.
Yes, that is within their knowledge. Within their knowledge. And they have mentioned the name, the person who has been appointed.
Yes, the same thing has been mentioned in the other writ petition also.
Page 48.
It's mentioned there.
That is why I am specifically when
There is no challenge. They have no challenge. They have to only challenge the notice.
Claim.
If they file the affidavit, I'll give the reply to that.
Learned counsel for the petitioner raises a contention as to whether the respondent authorities could claim parking charges from the petitioner, which the petitioner collected from vehicles near the vicinity of the railway property station in terms of an agreement, in view of the intervening COVID restrictions. Next para. It is further submitted that without terminating the petitioner's agreement, which was otherwise due to expire in the month of March 2024, the respondents have awarded same work to a third party. Next para, learned counsel appearing for the respondent authorities controvert the allegations and submits that from the impugned demand notice in both the writ petitions, it is evident that termination notice was given to the petitioner. That apart, it is submitted that by virtue of a circular of the railways, the petitioner is not entitled to any relaxation or relief during the pandemic period. Next para. Since certain factual disputes have been raised, the respondents are directed to file their affidavits in opposition within 3 weeks from date, disclosing all relevant documents and circulars having bearing on the adjudication of the issues. Reply, if any, shall be filed within a week thereafter. The matter
in 2 weeks.
Very well. Reply, if any, shall be filed by January 2, 2024. The matter shall be
our is maybe 4 weeks. 4 weeks.
আচ্ছা ঠিক আছে তাহলে এফিডেভিট ইন অপোজিশন যেটা বললাম উইদিন 3 weeks যেটা বললাম উইদিন December 19, 2023, which is 4 weeks. 23, reply if any shall be filed by January 2, 2024. The matter shall be listed for hearing on January 3, 2024.
Both the matter will be heard together.
Next para. WPA such and such and WPA such and such, এই দুটো number shall be listed for hearing together on January 3, 2024. There shall be stay.
One submission before that. This is a money claim. Your Lordship kindly consider, my lord. And this is a private limited company. They may go into liquidation. They should mind secure by way of bank guarantee or something like that. Your Lordship kindly consider this.
The respondents shall remain restrained from claiming the amounts which have been demanded by the impugned notices in both the writ petitions till January 31, 2024 or until further order, whichever is earlier.
So can the matter come up on 9th or 10th January? Because from 27 December to 8 January, I have some religious...
Achha. The returnable date 9th.
10th will be okay. Because 8th morning...
Returnable date January 10th.
So filing my affidavit service.
It will be returnable on 10th January. The rest of the things remain the same?
Yes, that will do.
Till January 31 or earlier?
So every service to be filed.
86 same order.
In both the matters,
Same,
affidavit service, Lordship.
56 is same order.
Both same.
Yeah, same order. Actually, yes.
Please ask your learned juniors to segregate between the item numbers for appearances so that it can be reflected in.
Item number দিয়ে দেবে না? আলাদা করে item number।
57.
57, my lord, I am for the respondent number
Actually, I am
3,
for the petitioner in this
West
matter.
Bengal Pollution Control Board, my lord, I have a preliminary objection, my lord, with regard to the maintainability of this.
Morning, sir. 57.
58, oh, I'm sorry. Not this one.
This is not regarding Pollution Control Board.
No, this is
But the Pollution Control Board has an objection.
The item 57, I'm sorry, ma'am.
Your Lordship, the matter is pertaining to Cooperative Bank, and one thing I bring your Lordship's attention that Honorable Justice Amrita Sinha has exclusive determination on Cooperative Bank and Cooperative Society. Despite that, the petitioner has
Lordship,
filed.
this is regarding.
Go to Justice Sinha.
This is Lordship.
This is regarding
Cooperative Bank,
regarding,
and I am appearing for the Santragachi Cooperative Bank.
This is actually I have taken a loan from the cooperative bank.
The counsel for the respondent bank at the outset points out that the matter that this court does not have, this bench does not have determination to take up the matter. Accordingly, due to lack of jurisdiction, WPA 24737 of 2023 is released from my list with liberty to the parties to mention for enlistment before the appropriate bench having determination.
I apologize for this.
No,
Much obliged.
I'm for the petition.
Yes, what is your objection?
My lord, section 22 of the National
58.
Green Tribunal Act 2010 says that if a person is aggrieved, my lord, against a decision of the National Green Tribunal, this provision is, my lord, an appeal before the Supreme Court. Kindly consider, my lord, section.
I was aware of this
Yes.
weapon, my lord, will be used against me, my lord.
So go to
my
the
lord,
Supreme Court.
There is judgment, my lord. This section 22 has been declared intra vires, but my lord, vis-a-vis, Lord, kindly come to the last conclusive paragraph of this judgment, Lordship.
Give a copy to your learned friend.
Lordship, the National Green Tribunal under section 14 and 22 of the NGT does not house a High Court jurisdiction at 26 to 27.
Yes.
The same is a part of the basic structure of the Constitution.
True. But the exceptions are, my lord, your lordship knows if there is a violation of natural
Then, my lord,
justice,
maintainable,
there
I
is
will
a violation of
Otherwise, it has to satisfy the
But this jurisdiction, yes, but the jurisdiction point, my lord,
maintainability issue goes in view of the judgment.
my lord,
Does
means-
not house the jurisdiction means it's
true,
maintainable. And
true, but one must
226 said-
show that the NGT does not have jurisdiction.
No, 226, whatever are the considerations, those manifest arbitrariness can also be a ground. Malafidus can also be a ground.
Here the issue.
Article 14 violation can be a ground.
That Article 14 violation has not been held.
This can be grounds
yes, yes,
theoretically.
certainly.
The moment it is said that 226 jurisdiction is not ousted, 226 window comes in. Yes.
My lord, the main ground here, my lord, this is an order. This writ application has been filed challenging the order of the Honorable NGT, my lord. And the main issue, my lord, is here my lord, the prayer which has been made, the issue which has been raised, that has not been even, my lord, framed. The different issue has been framed and a different adjudication was made. I'm coming to lordship. This is my lord, this writ application was fundamentally filed against a running of a ceremonial hall in dehost to the law relating to environment. My lordship, kindly come to page 90.
Let me deal with the maintainability point first, otherwise I'll later on forget. I'll just deal with that. I'll turn down your objection on this ground. At the outset, an objection as to maintainability of the writ petition is taken by learned counsel for the for the West Bengal Pollution Control Board.
Respondent number 3, West Bengal Pollution.
For the respondent number 3, West Bengal Pollution Control Board, on the ground that an appeal lies to the Supreme Court under section 22 of the National Green Tribunal Act 2010, full-stop. Such contention is controverted by learned counsel for the petitioner by placing reliance on the judgment of Madhya Pradesh High Court Advocates Bar Association and another versus Union of India and another, reported at AIR 2022 SC 2713. Full-stop. It is seen that in paragraph number 38 of the same, the Supreme Court came to the conclusion that the National Green Tribunal under sections 14 and 22 of the NGT Act does not oust the High Court apostrophe's jurisdiction under Article 226 and 227, as the same is a part of the basic structure of the Constitution. Full-stop. On such premise only, the Supreme Court held that section 22 is intravirus the Constitution of India. Full stop. As such, comma, the objection as to maintainability is turned down. Full stop. However, comma, learned counsel for the respondent number 3 is justified in arguing that it has to be ascertained by the court whether the limited window of interference under Article 226 of the Constitution is satisfied. Full stop. The matter is taken up for hearing on merits as a motion. Stop. Yes.
Lordship, kindly come to page 98. But I made a docket, my lord. Private respondent has been served, my lord, with the activity of service. My lord, I made a docket, my lord, against the illegal operation of this, my lord, ceremonial hall by the private respondents. And my lord, kindly come to page 98. This is the direction which has been issued, my lord, against the ceremonial hall by the pollution control
Page
board
90?
earlier. 98.
98, yes.
Your lordship will find it was on 6th of April 2022. Your lordship will come to
The date is missing.
My lord, your lordship will find it in page 100 in the forwarding notes.
All right, yes.
6th of April. Now, your lordship, that I'm just pointing out the relevant portion, page 99, the directions.
Yes.
That the point number 1, lordship, now thereof. Lordship got it. Now thereof, considering the above, the ceremonial house proprietor Sri Mukesh Bankar, located at such and such, is hereby directed as follows: that the unit shall make proper arrangement for ventilating the emission from the kitchen through a proper fume collection and exhaust system and stack of height at least 3.5 meters above the roof level of the nearest tallest building. That the unit shall install effluent treatment plant to treat the effluent generated from its kitchen activity. That the unit shall not use loudspeaker or sound system inside the unit premises without proper acoustic insulation arrangement to curb any dispersation of noise into the ambient locality beyond permissible limit. No loudspeakers stroke sound producing instruments will be used at night. The unit shall always abide by the guideline of ceremonial house, lawn, banquet halls, and the clubhouses issued by the state board through its circular under memo number such and such. The unit shall comply with the above mentioned condition within 1 month and submit a compliance report to the state board. Now, your lordship, thereafter also, my lord, my lord, I approached before the tribunal earlier. Your lordship will find it in the next annex in page 101. And my lord, the tribunal decided the issue earlier in page 69. Your lordship will find the relevant paragraphs. In paragraph 5, page 69, this is original application number 59 of 2022. I filed earlier.
Yes.
Your lordship will file in page 106. In paragraph 5, since the West Bengal Pollution Control Board has itself taken cognizance of the matter and issued appropriate directions, the directions I have just cited before, lordship, that directions, we are of the view that no interference is called for in the present case by tribunal other than to issue a direction to the West Bengal Pollution Control Board to ensure that its directions as given in its order dated 6/4/2022 annexed M of the original application are strictly complied with, and the West Bengal Pollution Control Board shall ensure that neither the sound level exceeds the permissible parameter in the premises in question, and that there is no garbage littered around the place and the place is maintained neat and clean, and there is no foul smell around the area as a result
Why
of the
did you challenge it? You wanted more stringent measures.
No. That has not been complied with. The second round of litigation came out, and the order
is not complied with. Why did you go to the NGT against this order?
Yes, I went there, and NGT.
Why?
I went
what
to
was the ground of challenge?
I went to the NGT complaining that despite of the direction of the Pollution Control Board and despite of the direction of the NGT to my lord execute the same, they continued the illegal operation, and my lord, to arrest that, I filed a second round litigation, and the order impugned passed in that application.
Yes,
my lord, your lordship will find in my second now, my lord, in my second round of litigation, my lord, this is in page 181. Your lordship will find in page 90 what is my prayer. Lordship, my prayer in prayer B,
page 19.
Page 90. Prayer made in my second round of litigation before the NGT.
Yes.
In which the order impugned has been passed. My lord, from prayer B, C, and D, I am, my lord, referring, I'm cutting short the matter, my lord, because of issue where the framed, I will show to your lordship that the B, to direct the respondent number 1 and 2, that is a pollution control board, to issue necessary directions and the further direction against the respondent number 7 and 8 for closure of the ceremonial hall banquet operated by the respondent number 7 and 8 at DA 41 Salt Lake City, Sector 1, Kolkata, such and such, with stoppage of supply of electricity, water, and
What
other
was the basis
services.
of this? You alleged fresh violations.
Yes, that unit continued its operation. Manmala Pollution Control Board didn't take any steps. Even the compliance report was not filed. And my lord, the Pollution Control Board allowed the unit to continue the ceremonial hall in the same fashion as they were operating.
It was allowed to continue by the NGT also, but subject to certain stringent conditions.
Yes, the conditions were not fulfilled. That was my grievance.
Was there a direction by the NGT to file a compliance report or something like that?
That was the direction given by the Pollution Control Board. Pollution Control Board. And my lord, the NGT, my lord, in the first order, if your lordship come to the next page, that your lordship will find that NGT, my lord, in page 181, in my application, this is the first order passed by the NGT in the admission stage of this original application. Lordship, the relevant paragraph is at page 185. The paragraph number 14 and 15, I am not placing.
Yes.
Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members: senior scientist from the West Bengal Pollution Control Board, senior scientist from Central Pollution Control Board, senior
the order passed on page 90.
181 continuing, my lord. 181 order dated, my lord, 28.
This is the order passed on the last challenge.
Second application, yes, my lord. Then the final order was passed. I'm challenging. It is the first order. And my lord, the next paragraph, the committee shall visit the site in question and submit its report within 1 month, bearing in mind the directions given by the West Bengal Pollution Control Board in its previous order dated 6/4/2022, as well as the directions given by the tribunal, the original application number such and such. So, lordship, the direction was given so that whether they are complying. Now, my lord, kindly come to the affidavit filed by the Pollution Control Board in page 187. The relevant portion, the lordship will find in page 198, the inspection report. The observation. The Alex Ceremonial Hall house is a G+3-story building, approx 1,000 square feet of ceremonial space on the ground floor parking area and 5 rooms on each floor, first and second floor. The third floor is meant for the residential use of the Banka family. During inspection, the house was found to be empty with no signs of any ceremonies having been held. It was found that fume extraction system has been installed, covered backyard of the house that is used as the kitchen during ceremonies. However, no other cooking equipment like oven, grill, etc. is observed. No effluent treatment plant has been installed. So there is a violation. Now, my lord, Mr. Banka submitted, my lord. Now, Mr. Banka submitted that the house is not being used for any ceremonial purpose since February 2023. After the expiry of the permission of UD and MA Department, Government of West Bengal, copy of the said such and such. Now, my lord, the remarks portion. Since the operation of the Alice Ceremonial House has stopped and the house is being converted to a residential building, no further action may be necessary now. But the past violations, my lord, and my lord, this is on the basis of the bankers undertaking that they will not operate it. And my lord, thereafter, however, in case the owners decided to restore the ceremonial house, the prior clearance is to be taken from all the concerned authorities, including the WBPCB, after ensuring compliance with the guideline issued by the CPCB and the directions issued by WBPCB, and also the unit should intimate this committee when the revised sanction plan is issued by the BMC. Now, my lord, this was my issue. It was found that they are non-compliant. They operated their unit by non-compliance.
What is the penalty for non-compliance?
My lord, that is exactly what I am on, my lord. And that is my prayer also. Then for non-compliance, my lord, my lordship, my lord, kindly come to the directions for once, my lord, for page 98 for once, my lord.
After this, another order was passed.
The final order I have challenged.
What
in the final order, my lord, the most striking part, your lordship, will come in page 284. All these, my lord, all this case, my lord, all this issue were not framed. What the my lord, tribunal did, my lord, tribunal by adjudicating, my lord, framed a completely different issue.
What was the occasion of the last challenge? This was passed on what? You challenged again? For
No, my lord. This was in that order, my lord, was a first order, and this original application was decided finally on, my lord. Your lordship
That was
will find
an interlocutory order.
Yes, yes. I am taking the advantage of that order. Yes, there is inspection. Let it be. Now, let you kindly come to page 273. This is the final order.
Right.
The order pronounced on 28th of July 2023. And lordship kindly see the most striking thing. Your lordship kindly come to page 24 of the order impugned. I think, my lord, this is enough for remanding the matter to the tribunal.
Page 20?
Page 284, page 24. Paragraph 24.
Yes.
My lord, setting all these issues aside, my lord, what the planet tribunal, my lord, what issue has been framed, the controversy in the present case, lord, you got it in paragraph 24.
Yes.
The controversy in the present case revolves in a very narrow campus, namely as to whether the ceremonial hall in question falls within the category A or category B. Lord, this was my simplicity alternative case that your lordship category of category B, lordship kindly come for clarification of that thing, lordship kindly come to page 114. This is the citing policy, my lord, of the Pollution Control Board, my lord, on 2021 by a circular. For the first time, the West Bengal Pollution Control Board incorporates the ceremonial hall within the consent management. And my lord, there are two, according to this circular, my lord, there are two categories of ceremonial hall. And my lord, ceremonial category A, my lord, ceremonial houses, lawn and banquet halls spread over an area of 1 acre or more, or having gathering capacity of thousands of persons or more. This is category A, they requires consent. And the category B, my lord, ceremonial house, banquet, less than 1 acre or less than 1,000.
Category B.
They are saying there's a category B, my lord. My specific averment was, that was my alternative case, that it requires consent, because my alternative case is page, para 15, 16, 17, and 18 of original application at page 70.
But your main case was that they are violating
steps. Yes, that has not been decided. No issue has been page 70, lordship, and that was also, my lord, decided in a wrong manner. Why I am telling you, lordship, kindly come to page 74 once in my original application. Para 15, 16, 17, and 18. Your applicant state that the
which page?
Page 70 of my. This is my part of my original application, and I will show to your lordship how it was decided.
Yes, sir.
Your applicant state, para 15,
yes,
from the observations recorded by the WBPCB while issuing directions in ceremonial hall banquet, it is evident the unit of the respondent number 7 and 8 used a part of the ground floor, first floor, and second floor setting up ceremonial hall where the local area is of 3698 square feet. Therefore, the gathering of more than 1,000 persons can easily be organized in said ceremonial hall. Your applicant have witnessed the assembly of more than 1,000 people in many occasions organized in said ceremonial hall banquet. Therefore, it can be safely contend the ceremonial hall falls within the category A ceremonial hall as per the direction circular of the West Bengal Pollution Control Board issued white memo number such and such. In the said ceremonial hall banquet of respondent number 7 and 8, therefore requires consent to establish, consent to operate under section 21 and 25, 26 of the Air and Water Act respectively. But what I am submitting, my lord, this was not my case that it was more, it is spreading more than 1 acre of land. It was my case that my lord, the gathering of more than 1,000 people I witnessed, and it is possible. And my lord, how it was decided? It was decided as if only 1 acre is the only criteria for, my lord, fixing a category. Or, my lord, and lordship, kindly what has been decided? How it was decided? Well, there are several other mistakes in this order, my lord. If I want to, I will go to point out, my lord, it will take another 1 hour to point out, my lord, the one after another mistakes. My lord, kindly see. Then paragraph 24 onwards, my lord. Then 25, 26, my lord, I am showing to your lordship how it was decided. No, that 25 page ইস্যুটা হলো ডিসাইড করলো। That you kindly see para 10, 28, 27, 28. Category A ceremonial hall, banquet hall spread over an area of 1 acre or more having gathering capacity of 1,000 persons above, located in municipal, you got it in the order impugned. Page 287. How it was decided. Even that, my lord, That question how it was decided.
So one objection here, one ground is that no proper
adjudication
issues were not framed.
And that was no occasion to decide the deal.
And A and B also there was mistake because the order
earlier-
was not taken into consideration.
Yes, that is in paragraph 27, 28, and 29.
Right.
27, Lordship kindly see. Category A, ceremonial halls spread over an area of 1 acre or more or having gathering capacity of 1,000 persons and above, located in municipal corporation area, municipal
What
area.
sort of interim order are you expecting in this?
My lord, if your lordship set aside the order and remand back the matter to the NGT for fresh
There is
adjudication.
an interim order.
No, my lord, that is if your lordship want to final order. And if your lordship call for the
Final order
affidavit.
cannot be heard today, yes.
And
call for the what interim order have you played? Was there in any event?
No,
says
yes,
that
my lord. In that event, my lord,
they won't operate as a ceremony hall.
My lord, that is
They are
their
saying
that is their undertaking. Let that be recorded.
That
That is their undertaking, and they should not.
I'll make that an order of the court also.
Yes. The injunction maybe.
Only one thing, my lord. My lord, we held an inspection. The inspection report says that there was they stopped, my lord, functioning. That house, my lord, stopped functioning as a ceremonial house. Now the question is, my lord, if the private respondents, my lord, are violating the order, or my lord, any decision of the pollution control board, there are other recourses, my lord. In any event, your lordship, my lord, certainly, my lord, pass, but my lord, direct the private respondent, my lord, not to use it as a ceremonial house because they themselves, my lord,
My lord, they went on a prior notice.
Learned counsel for the petitioner has raised several arguable issues. First, whether the West Bengal Pollution Control Board, by the impugned order, has failed to formulate the cardinal issue involved.
NGT, my lord, not
Sorry. The West Bengal Pollution Control Board, the
National Green Tribunal,
in its impugned order has failed to formulate the cardinal issue involved as to whether there was violation of the provisions of the National Green Tribunal Act 2010 and all pollution control norms. Next para. Secondly, it has been contended with some prima facie force that while distinguishing between category A and category B, the NGT has proceeded on the premise that property falls within category A only if the area is more than 1 acre by overlooking the other component as to more than 1,000 people gathering on ceremonial occasions. Learned counsel appearing for you are for the NGT.
No,
you are for the
West
learned
Bengal
counsel
Pollution Control
appearing for the West Bengal Pollution Control Board contends that as per the reports obtained on inspection, it is of the opinion that the private respondents have stopped using the property as ceremonial house, and as such, no further steps were required to be taken. Be that as it may, since a strong prima facie case for deciding the writ petition on merits have been made out, the respondents are directed to file their affidavits in opposition within 4 weeks from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed on January 8, 2023 for hearing. During pendency of the writ petition, the respondent numbers 8 and 9 shall remain restrained by an order of injunction from using the property in dispute, that is this DA41. That is situated at DA-41, Salt Lake City, Sector 1, Kolkata 7,64,000 for any ceremonial purpose whatsoever.
Until disposal of this.
Pending hearing of the writ.
Very grateful.
Very short matter, 2-minute matter.
Settled, my lord. The first matter, original side, lordship wanted bank to take instruction. 2 minutes, not more than that.
My lord, I am for the auction purchaser. Now I have paid money, and the issue in respect of my right is pending adjudication before the.
My lord, may I just sum it up, my lord?
If
Give me 1 minute, my lord. Nobody's right will be affected. Everybody would be, my lord. Their right will be protected.
One call.
Original side, item number 1.
Yes.
My lord, it was, my lord, settlement amount was 2.10 crore. 1.81 was what the auction purchaser was to be.
Oh, that.
Yes, my lord. So bank was to take instruction, my lord, 24 lakhs, whether they would take from me, balance the amount, and whether it would be done. I spoke with my learned friend. My lord, the bank is agreeable. He only points out that there is one correction which I also didn't know. My lordship remembers, my lord, showed the DRT order which recorded that 1.81 was paid. He says bank on instructions from bank that it was 10% of that amount that was paid, and auction purchaser is ready to pay the rest, 169 something, whatever is rest. I am ready and willing to pay 24. So matter can be settled now, my lord.
The sale has to be conducted by the bank, the authorized officer of the bank. That cannot be done, my lord, beyond settlement, because that was done. This is a statutory exercise, and that has to be done by the authorized officer. If, my lord, can you add this line?
Lordship, may I add it?
I don't have any.
Can you bring an agreed order on
My lord,
Thursday?
I can do this, my lord. I can prepare, my lord, a draft, share it with both of them. If
Share.
all of us are agreeable, we need
Do
no
it,
trouble.
do it by tomorrow. You have tomorrow also.
Yes, we can.
So
And lordship may keep it then, my lord.
keep it on Thursday.
Thursday.
We are reopening.
Thursday, yes, Thursday.
Thursday at the top, so that we can resolve
Yes.
it. Just bring an agreed order. If there is any discrepancy in that, I mean, let us.
Lordship will modify.
Freeze that out.
Yes, very well.
Technical part, just take care that it is an agreed. If
So
it's
that
an agreed
nobody's
order,
rights are affected.
yes,
My lord,
I'll
just
take that on
the-
record and pass an order in that.
My lord, the correction can be done, my lord, this of the last order, my lord, which passed.
Yes,
my lord.
that correction,
My
lordship
lord,
will
that
do that,
correction
my
is to be done.
What correction?
My lord, in page 2, paragraph number 3, my lord.
Yes.
It transpires that upon hearing both sides, insofar as the consideration of sale 1.8 crore is concerned, the same is
10% of
already on the hands
1.81.
of the banks.
The same is already. It will be 10% of
10% of
My lord,
1.8.
it's only 18 lakh 10,000 is with the bank, not the
After order record kone. In the order
Because there was a stay order passed by GS.
in the order dated November 16, 2023, comma, as rightly pointed out by learned counsel for the bank, comma, it was recorded in the third line of the third paragraph of the second page of the said order that insofar as the consideration for sale of rupees 1.81 crore is concerned, comma, তারপর double inverted মধ্যে the same is already in the hands of the bank, ... double inverted close, full stop. However, comma, it should be read as within double inverted, insofar as the consideration for sale of rupees 1.81 crore is concerned, comma, 10% of the same is already in the hands of the bank, ... double inverted close, full stop. This order be deemed to be a part of the said order, full stop. Since there is a scope of consensus between the parties, comma, all avenues of settlement be explored, full stop, for such purpose, comma, expecting that the parties may come with an agreed order, comma, the matter is adjourned till November 23, 2023, when it will be listed at the top.
Well, one line that the auction purchaser is represented.
First up, it is recorded, it is hereby recorded that the auction purchaser is also represented to counsel in court today.
Grateful,
Will-
my lord.
and will be paid his full fees.
Grateful, my lord.
Grateful, my lord, may I prefer a small indulgence, my lord? I had mentioned, my lord, 51 matters. I've given a list, my lord. Those matters are infructuous, my lord. I was humbly praying, my lord, because if your lordship sees the list,
Definitely, সব করে 51 দিয়ে দেবে।
I've handed over in the morning, but I could not mention, my lord.
Appellate side এ।
Disposal হয়ে যাবে।
Oh, I will. It's
No,
the
this
appellate side.
disposal is not that disposal.
Those are
Only the High Court is relieved of.
yes,
some
my
matters.
lord. And my lord, I am relieved from my office, my lord. Those files, my lord. That is great.